after 2 weeks, man, but yet not listed.
Give. All posting give.
Obliged, man.
My lord, similar to content notice, my lord.
Give that.
May I seek your lordship's indulgence? My lord,
170 of weekly list matter. The matter is going to be infructuous because of this is a matter of disqualification at Sarpanch minor, and basing on the order of this
When it becomes infectious.
my lord,
When it becomes infectious.
it is infructuous coming week infructuous.
Coming week. So when which date it will be effective?
The collector has already been passed the order 170.
Yes. Next week we'll have that.
Next week.
my lord,
Next week.
may I seek your
It may be taken a supplementary list.
Daily list. Awesome.
Outline.
Start.
170.
118 of the weekly list covered matter you are.
Covered by the judgment.
Yes, you are.
Wait, you give
118 of the weekly list.
you give to copy
No, more than copy.
because long list they will not be able to know to
I have
whom it
already
is
solved.
allotted.
Mr. Mahathi, I have already solved.
Amonti, just look into if it is there. Wait.
Supplemental list, item 25.
No, wait. When it will call it afterwards. No? They have to look in.
Item 25 of supplemental list.
25
My lord.
of daily list.
Supplement.
Yes,
Supplement,
yes.
Senior Counsel Mr. Ashok Mahathi is on accommodation for 2 days. Today and tomorrow.
Next week.
my lord, item number 28, my lord.
Sorry,
You are for the petitioner.
yes, my lord.
Request of the petitioner.
Not say item 16 of daily list.
My lord, item.
I am opposite party in this.
He's mentioning again, you will overlap.
Wait, we'll hear you. Yes.
Not say item 16 of daily list. I am opposite party bank.
Your bank.
Sri Guru Datta Kora. His paternal father died today morning.
Is it?
After kindly taken out Monday or Tuesday.
No, Tuesday. Tuesday.
Right.
On the at the request of. Okay.
My pardon, your lordship, interim order to be continued in the same matter.
Then we'll have it after 3 weeks. Or we'll call after 3 weeks.
Dear my lord, I am for the auction purchaser. In fact, the repeat sum was filed at my base.
Next week. Next.
I'm sorry, my lord. My
Interim order
senior
to-
is actually not available for the next week. 2 week will be.
Let it go on 7th, my lord.
On 7th we'll. 7th? No, 7th not possible. We have posted 11 matters on that day. Call this matter in after 2 weeks. Okay.
Obliged. Your lordship, item number 18.
What name?
Supplement. Yes. I'm appearing for opposite party. OSFC.
What you?
Sir, my senior London advocate Amit Patnaik, due to some personal difficulties, he could not appear.
What time?
Yes, lordship.
So who is your opponent?
My lords, I am for the petitioner. It's okay, my lords. He had also requested me. Let it come a week after next, my lords. Next week I won't be there. Any date, week after next.
After 3 weeks we will have.
My lords. And the interim orders will continue.
You have interim order? Then after
Yes.
4 weeks. Yes, next.
May I
Deeply
please,
obliged.
lordship? Lordship, item number 143 in weekly list, lordship. Lordship, my humble submission is can it be listed in supplementary list, lordship?
What is the special?
Lordship, actually, lordship, the Sarpanch election will be held in the month of April, lordship. I am removed from my post.
Sarpanch election.
Yes, lordship.
You are removed from that.
Yes, lordship.
Yes, even otherwise elections will be held. You have, how it becomes infectious.
Yes, lordship. That's
Then election will be.
April in the month. It likely to be held in the month of April, lordship.
Is it? Post it on. 9th of April. 9th of April.
Supplementary.
Yes, put it in daily list, supplementary.
Highly obliged, lordship.
Pardon to mention, my lord, the writ appeal of 2024, whereby the merger of two cadres, housekeeping staff of international airports and domestic airports. But Lord, next week.
Next, even if it is posted, we will take time, I know. Therefore, let it come after 2 weeks.
I beg your pardon, my lord.
Next week, call next week.
I beg your pardon.
Some other bench.
It's
Yeah.
an eviction matter, eviction appeal, writ appeal is there.
Huh?
So eviction matter. So that's why I pray, my lord, next week because
Next week.
and another one is the GPF on interest. That will
Both next.
much obliged. And one item 167 of a weekly list of my lord's court now. That is also eviction matter. That has been, my lord, directed for supplementary. Some of the matters not listed, but can it be taken up supplementary list in the next?
It was ordered that way.
My lord, eviction, no, that is memo, on the memo. While I was mentioned, my lord has directed.
It has come in the weekly list.
In the
You want to
weekly
bring
list,
it in
item
this
167.
daily list.
In,
Should keep it to do.
I don't know.
Item number 24 of a list. Next week, man.
24.
24.
Next week.
Pardon to mention, your lordship, this is the IN number 1192/2026. We are filing this memo for the recalling the order dated 25 February 2026. Yes, your lordship. Your lordship, 2 minutes time to explain this matter.
Wait, when did you post
It is arising out of a diary rate of bill number.
Is it posted today?
No, your lordship.
No, post it after 2 weeks, as it is.
Oh.
As it is.
May I seek your lordship's indulgence, my lord?
Yes, sir.
My lord, item number 28 on your lordship's board. Item 28.
Yes.
My lords, I have some personal difficulty today, my lords. Any other days that convenient?
Next week we will have that. Next week.
Your lordship, on the week after, may I pray?
Week after we have already posted many matters. Next week you can argue that matter.
Next week.
person.
Huh?
Petitioner is in person.
Petitioner is in person.
He is in person. That is why I mentioned in the first hour. my lord.
All right, call this matter on 30th of March.
Obliged.
Kindly inform the party in person.
I will, my lords. I will.
That 118, that weekly list, cover matter, I have already solved the topic, may be listed tomorrow.
It should keep to tomorrow's list. Covered, because they have to look into.
They have to-
They cannot read and, yes.
Tomorrow, the list is also.
Item number 1, warrant of bill 2917 of 2024.
Yes, brother.
May I please,
24 matter, first time they are coming now.
my lord,
First time they are coming.
after March persuasion by your memo, my lord.
Yes, brother, what is that?
My lord, petitioner is a retired person. My lord. He was retired on 30th June 2020. And he approached.
This is the post notice or
First time.
first time? What happened?
Petitioner retired on 30th June 2020. After his retirement, he submitted a series of representation for sanction of his pension and benefits, so also unutilized leave salary. Unutilized leave salary, which was at his credit, my lord. Then, my lord, they rejected
Okay, so leave surrender. Okay.
leave salary, my lord. That is not related to retirement leave. It is his, at his
Independence.
independent, my lord. So they rejected my representation, stating that on the day of retirement, departmental proceeding was pending, and vigilance case was under investigation. My submission before your honorable single judge is that on the date of retirement, no departmental proceeding was pending against me, since no proceeding was served on me on that day. So far as the vigilance case is concerned, no cognizance has been taken on the date of my retirement.
Now is it taken?
Now taken after my retirement.
Similar matters, what we have said is, you can renew your request depending upon the outcome of the criminal case.
My lord, so the honorable single judge formulated 2 questions, my lord, in the judgment. One is when the departmental proceeding is said to have been initiated.
So that all that pales into insignificance. Once cognizance is taken,
Cognizance-
the criminal case subsequently.
Subsequently.
Therefore, it is, we are telling that.
So,
We have already taken that view.
and there is a circular clarification of the government that only the pension can be stopped, withheld, only after cognizance is taken. That circular also placed.
Leave salary need.
No, there is no such provision under the, so far as the leave salary is concerned.
We are asking you. We are telling something in your favor.
My lord.
If you say no, very well, then we'll dismiss the appeal.
No, my lord.
We dismiss the bill because you agree with our view.
No, my lord, I could not able to get my.
Therefore, you should always give attention to what the judge is saying.
Yeah.
All right. You mean to say, law does not provide for withholding of surrendering of leave salary. Yeah, that is encashment of leave salary.
Yes.
Is permissible. That's what you are saying.
Yes. So far as the vigilance case is concerned, law also permits to grant pension, which is entitled to by the next day of the retirement, since no cognizance has been taken.
He is getting provisional.
He is getting provisional pension.
We have already decided that
Well,
provisional pension will go on subject to outcome of the criminal case.
no, that is not the there.
We have said
We have
that now
said
in other matters.
Perhaps I could not able to convince my lord.
No, we are unable to convince you. We
That-
have
the coordinated.
identical question arose before us in half a dozen matters. We took the view, even though cognizance was not taken as on the date he demitted office on attaining the age of superannuation. Subsequently, if cognizance is taken in a criminal case, the provisional pension will go on.
No, we are getting, my lord. There is.
Therefore, it is correct order.
No, my lord, I'm
Only your surrender leave is concerned, let us take notice. Let us see.
and so far as my lord,
Right, issue notice, submit it towards operations for the OBs. Matter lies in a narrow compass, post it in the first week of the immediate day of the summer vacation. Okay. Next.
Item number 2, writ appeal 1099 of 2025.
Yes, Mr. Monti, what is this matter about?
This was in the weekly list, my learned friend has made a mention yesterday.
What is this matter about?
This is matter, my lord, challenging the order of the Hon'Ble single judge,
Correct. All appeals.
Wherein,
are
my lord,
orders.
the post as has been advertised in the year 2013.
2013. Which post?
It is the post of Assistant Engineer Electrical.
Advertisement is dated.
I have prepared a short date chart and note. Can, if the lordship's permission, can I give it?
You? Let him say now. Yeah, Assistant Engineer Electrical. Advertisement is dated.
2/8/2012.
How many posts were notified?
This was, my lord, 38.
Right. 38 vacancies.
Yes, sir.
All right. Then what?
My lord, subsequently, process was on, my lord. While it was completed, my lord, in the meantime, it is seen that the reservation was more than 50%, my lord. So one of the candidate has preferred challenging the said selected list before the Hon'Ble tribunal, my lord. Then tribunal has considered it in 2013.
And allowed,
Yes, sir.
saying it cannot exist because of Indra Sahani.
Indra Sahani. Yes, sir. Then subsequently the same was recasted, my lord, that particular one.
That tribunal's OA number or what is that?
This is the OA number. sir.
OA number?
2478 of 2013. Challenging the selection list dated 17/7/2013. Hmm.
17/7.
2013, you know.
Passed.
Yes, well, on the ground of violation of reservation policy and the ceiling limit.
First wide order dated
29/1/2014. Then, my lord, keeping in view the reservation, my lord, the 38 became 29, my lord, within the ceiling limit.
You reissued advertisement.
No, no. Only we have considered.
Select list you prepared separately.
Yes,
Afresh.
Exactly.
Okay.
So then SCBC category became 6 million. In earlier
OBC.
social education.
OBC.
OBC.
Yes.
So then prepare the list, my lord. Serial number 1, 2, 3, and 4. Not 3, my lord, 4. 2 and 4 not joined in service, my lord.
2 and 4.
Of the select list.
Of the select list one.
2 and 4
Present,
SCs or SCBC?
they are SCBC. On merit,
SCBC.
That
In
is
your
the-
roster, it is 2 and 4 is SCBC.
SCBC. But they have been upgraded there. They have been placed under the UR category
Oh.
because they are
Because of
meritorious.
merit. Because of merit, they
Merit.
have not been taken in SCBC but on merit.
Merit,
You are.
they have found
General.
place exactly in general category, UR category. They are found place in serial number 2
2 and 4.
or 4.
They did not join.
They didn't join.
Huh.
2, 4, 12. My lord, 12.
3, 2,
No.
4 and 12.
2, 4 and 12.
3%.
3%. এটা ঠিক না? 1, 2, 4 and 12. नहीं, 1 টা अलग category যেহেতু আছে, but 1,
Let's
2,
have you.
1,
How many
2,
did
4
not join?
My lord,
1, 2, 4, 12 who did not join.
didn't join.
My lord, total 11% did not join. Since we are concerned with UR and SCBC, we are not concerned with SC and ST.
For that we are limiting.
The four persons belonging to these category, UR and SCBC, did not join out of the appointment order issued in their favor.
Right. So 4% did.
Yes.
1, 2, 4 and 12.
1, 2, 4 and 12. 2, 4 and 12. Though belongs to SCBC category, they have been placed under the UR category on merit basis.
Percentage is correct. Now they are under the.
The
UR.
present petitioner, the respondent,
Hmm.
found place in serial number 14 in the SCBC category.
Huh.
When 12 didn't join,
Huh.
13 belongs to SCBC category, placed in 12 million. Am I clear?
Good, understood.
Then the 14th claim is my lord. So far this writ application.
14 is your claim.
Yes, ma'am. My learned friends claim. So far the single, my lord's honorable judge, single judge, my lord, there the verdict is, my lord, they should be placed in 7 and 9 because 7, 9 belongs to SCBC category. When 2, 4
Did not
belongs to your category and didn't join, though the SCBC category candidates on merit placed in 2 and 4.
because they were more meritorious
Meritorious.
Has to be otherwise.
than the UR category.
Your category.
Those who did not join.
Those who did not join.
Is it true?
My lord,
We are asking. Yeah. Is it true whether the candidates 2 and 4 they were SCBC?
Yes.
They did not turn up.
They did not.
There were others also with which we are not concerned. Therefore, others who were in the next below,
Yes.
not immediate, but
Not-
immediately next below,
Yes.
they have been brought to those positions.
that is what they didn't do. And now the Honorable Single Judge has directed, since 2 posts belonging to UR category, you have selected and given appointment, did not join, the persons who are below them are to be upgraded to that as against those 2 higher posts. And accordingly, this person will be accommodated. That is what the Honorable Single Judge has directed now.
Then where is the mistake?
Lord, question is, when 2, 4 belongs to SCBC category but found place in the your category on their merit and they didn't join, the 12 and
If they do not join,
yes,
the roster remains intact.
remain.
Candidates may not.
The candidate,
Suppose, for example, one SC candidate, ST candidate, he is more meritorious. Then he will march over as a your candidate only.
exactly.
But post earmarked for roster in the
Remains
roster
as it.
remains as it.
As is.
Huh.
But fact remains, my lord, subsequently the 9 extra post because it changes from 38 to 29 because of this resolution by virtue of the order of this honorable court. When 9 posts remain there, my lord, subsequently it was brought forward to other years, my lord, and subsequently 3 successive years they have been adjusted so far the extra post is concerned, so far the 9 post. So in fact, so far it is a recruitment for the year 2013.
No, that's all right. But we don't travel to that level at all. his client is brought to the higher level because they did not come.
Well, they did not come, but 7 and 8, 7 and 8, well, they are saying, they kindly have a glance to the finding of the
7 and 8 or 7 and 9?
7 and 9.
9.
And have a glance to page 27, page 7.4.
This is perfectly in accord with that Mandal decision.
Yes.
Subsequently, Nataraja versus
And your Lordship's constitutional bench judgment in 1995 Supreme Court. My lord, I have given 4 judgments. Specific, I have pointed out those paragraphs.
that latest judgment of Justice Gawai, which treated this aspect.
My lord, R.K. Sabharwal judgment.
That is earlier judgment.
Yes, that is the constitutional bench judgment. Paragraph 4 clearly clinches the issue that where a person belonging to the reserve category coming under social reservation or vertical reservation secures more merit,
He does not avail the reservation at all.
even if he belongs to that, he doesn't allow to, he will not be allowed to consume the vacancy meant for that particular category.
But fact remains.
Later on, Justice Maheswari has passed it.
Yes, my lord. Yes,
Only-
your lordship is, yes. BSNL versus Sandeep Kumar, Saurabh Jadhav. My lord, all the-
R.K. Sabharwal is the
And
best.
when it on 23rd, today we are in 25th. On 23rd, Honorable Supreme Court has, I have come across, I have come with that judgment where this principle has been reiterated and referring to the Jitendra Kumar Singh judgment, they have gone further. So it is the settled position all through that whenever somebody exhibits higher merit, he cannot be constricted to the reservation category because he was born in that particular category. That is what, and your lordship will be strated the very select list on which they are embanking upon. My lord, Honorable Single Judge has specifically referred to the persons who were selected at 7 and 9. My lord, the reason being, my lord, they have taken even serial number 8 and 10 as your category. Even if serial number 7 and 9 they have treated as SCBC. That means even if those 2 persons secured higher merit position, instead of taking to the you by considering them as persons belonging or selected under SCBC category, they have consumed the SCBC category and denied me. Even if I have been selected by the Odisha Public Service Commission. My lord, you will also kindly see the merit list 17/7/2013. I have all that these are there on record. Annex 2 is the select list. Your lords may kindly say I have given 2.
Mohanty.
77 to
R.K. Sabharwal.
I am conscious,
principle.
Kind of a
On
glance
which
of
judgment is structured.
7.4 million of the
7.4
finding of the Honorable Single.
Therefore, the ground on which petitioner claim has been rejected by the one decade, so it's so considerable that this court is not sustainable in the eye of law. Therefore, this court will come to brush the sides to provide appointment to the non-judging of the candidates placed at serial number 2 and 4, with the adjustment of candidates placed at serial number 7 and 9. 7 and 9 are UR.
7 and 9 are
SCBC selected under SCBC, even though they should have.
They were more meritorious.
They are more meritorious, but still they are selected.
Adjusted again.
They should have been adjusted. That is the flaw committed by them, and the Honorable Single Judge has directed that they should be adjusted against your post.
My ground in L, my lord. For a moment.
Ground L.
L. That is page 14.
Go to L.
This is directly against this Honorable Supreme Court's judgment. Your Lordship is referring to just now.
No, this itself is wrong. L itself is wrong.
Yes.
Because 7 and 9 candidates scored more.
Yes.
More than the Millard 14.
Yes.
Yes. They scored more and therefore they marched ahead not as SCBC candidates. They shut their character as SCBC candidates. They assume that mantle of UR category.
But 2 and 4, though belongs to SCBC category.
Correct. They did not join.
They did not join.
They
but
also had scored more.
They have scored more on their merit.
Mr. Bhanti, candidate shedding the character of SCBC, SC, ST because of they being more meritorious is one thing. The vacancies being earmarked, they remain as they are. They will not change. Merely because a person who has scored more, if he is appointed to the UR category.
Your category, on merit mean.
Unmarried.
Not
That
on.
is what, no, therefore, but they were L itself is wrongly
If
structured.
at all 7 and 8 will be the 2 and 4.
Very true, but he has not come and instructed. What my brother is saying is, if he has availed the benefit, then he cannot turn around and all those things. But that question may not arise because they have not come forward only for appointment. No, brother.
Then it kind of recasting, my lord.
Nothing like
If at all, in the meantime, 4 advertisement has been made, and they have successfully, they have been appointed. These persons have been appointed since 2013. Now, if at all, they will be placed above of the persons.
which happens. What you have to?
My lord, the entire system.
Why? Because you did it. You invited that, you pulled down that.
No, my lord, because it was
structure on
more
your
than the
side.
reservation, and by virtue of this honorable court's order,
Since impute judgment is structured on the foundational principle of RK Sabharwal 95 judgment.
Yes, 95 Supreme Court. I have given copy.
95.
Your Lords may kindly see the copy I have.
As has been created in reiteration happened in which case?
My lord, in Sandeep Kumar, my lord, just a minute. My lord, reiterated in
RK Sabharwal, they are 1995 SC1.
Rajasthan Public Service Commission versus Rajesh Daria, paragraph 9. Again, Saurabh.
Not again. Latest, which is the latest?
Latest, my lord, BSNL versus Sandeep Chaudhary, 2022,
And,
11 SCC 779, para 9.
no,
just
as reiterated in
2022, volume 11, SCC 779, para 9.
the Justice Gawai's judgment.
Justice Nagaratna's judgment.
No, there is Gawai's judgment also, na?
Yes, yes, thereafter.
Which is one, there was one judgment of Hon'Ble Justice Gawai.
Well, I'll give that. I'll give that. My lord, with regard to, sorry. My lord, the honorable single judge, because of the submission made by the State Council, has directed me to file an undertaking that don't claim anything, simple appointment, even if the rule is otherwise. Your lordship knows, my lord.
But you have given undertaking, na?
No, I have not given.
But a learned single judge has worked out equities. So
You did not challenge it also.
No, I have challenged.
Huh?
I have challenged to that limited extent.
Yeah.
Yes.
It is also here.
Yes, I have filed that. I am giving that WA number.
But correct. But learned single judge in his discretion he has done that.
Yes.
But it's up to your lordship. Because I say, my lord, that would my lord, it's subject to your lordship's
will
consideration.
not claim any benefit of seniority besides.
Why I say so? My lord, rule says it's covered by a 309 rule. The rule says whenever there is a direct recruitment, the merit list prepared by the Odisha Public Service Commission will govern the seniority. Here my position is at serial number 14. Persons up to serial number 38 were appointed.
But problem is you will march over.
So your lordship
given. You will march over.
Your lordship,
that creates the heartburn.
can I, my lord, yesterday, your lordships, I was sitting here, your lordship has been magnanimous in granting that notional benefit. Can I pray, my lord? Let them give me notional benefit so that the wrong committed by the process of which I am the victim.
Notional benefit means what?
Notional the benefit.
How many years?
My lord, from 17, your lords may kindly see.
Sorry, asking you a question.
From 17 onwards, when the first non-joining candidate, serial number 12 was given, my lord, by kindly see. In the year 2012, I approached the tribunal, so also the person who has serial number 13. Against the non-joining vacancies 1, 2, 4 and 12. That serial number 13 was given appointment in 2017 as against serial number 12. But I was not favored with. Now the honorable single judge has granted that benefit to me. Well, I have enclosed that copy in that is also part of Annex of 13 before the 13 series. There, my lord, he was appointed in 2017. At least from 2017, just like the Sushil Kumar Meher, who is at serial number 13, just above me, I should be treated like that. That is what my prayer before lordships. Because, my lord,
Notional benefit means what?
notional benefits means, my lord, from the very same select list, as against 29 posts, not as against 38, the tribunal's direction has been ratified.
You want to become senior to those 29 also?
Not SC/ST people, not against UR or other posts.
Even if SC/ST people are also human beings only.
I say because I have exhibited more merit in the selection process. My position is at serial number 14, and persons below me were appointed, and even non-joining vacancy against government has given appointment in favor of Sushil Kumar Meher in the year 2017. So at least I have gone before the tribunal. I have enclosed the order of the tribunal. Same day, tribunal passed 2 orders, one in favor of Sushil Meher, another in my favor. They respected the tribunal's order in respect of Sunil Kumar Meher and appointed him, who is at serial number 13 against serial number 12 non-joining vacancy. But so far as my case is concerned, they have rejected it. That order of rejection became the subject matter of challenge before the this honorable court. Now the honorable court has quashed that rejection order of 2018. So I have been pursuing the litigation right from 2013. But my medical examination was over after the select list was prepared. And the original application is not maintainable.
You give him 5 years seniority.
Without things will be recast.
Because of you. He suffered because of you.
Let's say,
And how can completely some adjustment has to be done? You give when did you approach the
Honorable Single Judge?
Well, I approached the tribunal.
7.5 minutes.
I approached the tribunal way back in 13. I approached this honorable court, which confirmed the order of the tribunal in the year 2017. I approached the tribunal in the year 2016, alike Sushil Kumar Meher. Now the rejection order of 18 has now been passed by this honorable court, which is now before lordships for consideration.
7.5 kindly have a glance. And if the wisdom has passed this order, can have a glance over it.
That is
order of the honorable single judgment. Page 27.
I'm challenging that partially because of the undertaking.
You cannot direct him to file undertaking. You can ask him to give undertaking.
Language may be different, but the intention
anyway, the learned single judge has said what we will do is, see, he has completely wiped out the earlier period. That may not be. That will be too harsh to him because he suffered at your hands. Because of your mistake, he suffered. R.K. Sabharwal, 95, 92, Mandal district, Indra Sahan. Long ago, principles have been settled. Why your officers did like this? Let them go seriousness. And accordingly, 50% of seniority. 50% of seniority you do. Without money.
Because the person, those who have been appointed since 13 and 17.
Correct. But they, in fact, had he been given the appointment, he would have been senior to all of them. To all of them, he would have been senior.
You will also sacrifice just like 5.
7, 9, 12 are there.
Yes. How he will be agreed by that?
And this person is in 14.
Yes. If at all it is a point, it is for the persons who have been marched over. They can say all this. How can the state say this? How can the state say this?
But practical difficulties will be
nothing practical. They will be pushed down. They will be pushed down by one number. By one number. Companion appeal of the employee partly allowed, and paragraph 7.5 of the impugned order is modified to the net effect that he should get the, although his appointment is prospective, he would get, he should get 50% of the seniority. Of course, without any debts. Structure according to that.
And the fixations will be notionally fixed. Pay will, your lordship, since your lordship grants. So naturally,
everything will happen.
Yes, yeah, that's it.
Consequential.
Yes,
other consequential conditions.
My lord, the number of the respondents' appeal is 124. I am giving a cheat.
It is there, right? Today.
No, my lord. This is not there. This is
get it posted.
Yes.
Get it. Matter post.
Oble. I am giving the number.
WT number?
WA 12415 of 2026.
How communication should be?
Well, I am giving a cheat. That is what.
Yes.
I am giving a cheat.
Good.
My lord, can I pray, my lord? The Honorable Single Judge has granted 4 weeks time for carrying out the order.
6 weeks.
But
6 weeks.
But now, my lord,
6 weeks.
1.5 years has gone.
No, in 6 weeks.
Oble,
Order to be implemented in 6 weeks. But for this, you should give an undertaking.
My lord, as your lordship will direct, because I.
No, we are telling you. If you are agreeable to this one, then we will see.
Getting more than the expectation, so undertaking is inevitable.
This is subject to employee filing an undertaking, agreeing with the same, and not otherwise. That undertaking to be filed within 4 weeks of this date. That's all.
Item number 3, Writ Appeal 1980 of 2025.
My lords, if it state challenges the judgment and order passed by the learned single judge by striking down a standard procedure operation prepared by the state, my lords. My lords,
Standard operation procedure.
The fact is like this, my lords. Central government took a decision to insert vehicle location traffic devices.
Vehicle location traffic
Tracking devices.
Where that vehicle is at a particular
My
time.
lord. So after that Nirbhaya case, Supreme Court's direction.
Laid down certain guidelines in terms of that. Yes.
My lords, that device specification is prepared by the central government.
How that device should be.
Yeah, the standard.
What all features it should have.
Yes.
What is the structural model it should be. These things are decided by the central government.
Central government. My lords, the state government was given responsibility of back-end system, providing back-end system, the registration, the activation, the health checkup, and alert. My lords, it includes emergency button also, so that it will be allotted to the monitoring center. Monitoring centers will be set up by the state government. It is state's responsibility given by the central government to the state. Alert updates of the VLTD, vehicle location tracking system. So, my lords, as per the, it was inserted in the rule 125H in the motor vehicles rules.
State or central?
Central rules. And as per the rules, the central government prepared a model SOP and circulated to all the states and union under territories to have their SOPs to registration, whatever
implementation of
the order. Accordingly, 12 to 13 states by now, they have adopted. Maharashtra has adopted, Kerala adopted, Karnataka adopted, lot of states. So, my lords, our state government also adopted SOP. In that SOP,
the model SOP was given by the central government.
My lords, in that model SOP also, it was there is a provision. There is a provision. The state has to prepare their own SOP. It is specifically stated. My lords, the dispute arose. The petitioner filed a writ petition challenging some conditions in the SOP.
What was the condition?
Those conditions, what was challenged by the petitioner, in the SOP, there was a provision for registration within the state. They should have an office, local office. Because, my lords, it operates like this. The device will be installed. Then, in the monitoring center of the state, they have to activate so that it will work, my lords. Show state the reasonable restrictions, whatever your lord. State has formulated that you should have a office and you should register within the state. Otherwise, my lords, why in the SOP, it has been the reasons and objects also given why it is necessary.
Do you have that power?
My lord.
It may be very attractive, laudable, one thing.
My lord.
Whether do you have power to do it?
My lord.
Under the rule itself.
My lord.
That is how the single judge has said, consider.
My lord, single judge has stated that you have the SOP adopted by the state is conflicting to the central SOP. But what I will submit, my lords, it is only supplementary to the
central.
And in the center's SOP, it was specifically advised to the states to have their own issue.
So sometimes there may be conflict also. Even then it will, first contention is there is no conflict at all.
My lord.
Assuming that there is conflict, since it is only a model SOP,
my lord,
that has been adopted by us with the suitable adaptations to our situation, conditions.
My lord.
I think similar matters were considered by some of the high courts in the country who appeared for the other side.
Appeared for the petition.
Karnataka High Court has it appears Karnataka High Court has held against you.
VLTD, but I'm not aware about Karnataka High Court. In some courts, this
matter requires deeper.
In Tamil Nadu, they have withdrawn similar.
That's all. Yes, that is for the state of Tamil Nadu.
May I just outline the?
No, matter requires deeper consideration. It's a serious matter. We cannot just by at the admission stage we cannot dismiss the or allow the appeal. It requires deeper consideration.
Yes.
Issue emergent notice to the heard learned DG Mr. Berura. First off, very many points have been advanced for consideration. First off, the judgment will have improved judgment will have far-reaching consequences, including those of federal nature. First, matter requires deeper consideration. First, next paragraph. Any caveat you have entered?
Yes, I'm appearing on caveat.
Do you want to say anything? We are staying this. We'll fix it.
It's already in operation. They have complied with the direction of the Honorable Single Judge.
My lords, I am not confining it to the petition.
For others,
my lords.
May I, if my lord permits, then may I just draw an outline as far as prima facie case is concerned, because I fully appreciate the matter requires deeper consideration. My lord, the SOP framed by the state government was challenged essentially on 3 grounds. The first ground was lack of authority or competency. The second was inconsistency with the central rule. It was direct inconsistency where both of them could not stand together. The third was that these restrictions have been imposed by way of, this is the nature of executive instructions. So it impinges on Article 19(1)(g). So these were the 3 essential contentions on behalf of the petitioner.
Yes.
Well, for that, the statutory scheme The matter is fully covered by the Central Act, the rules, and a statutory order issued by the central government. So the principal grievance arose like this, Millard. In 2016.
We can hear the main matter itself, some date will fix
Yes.
till that, because many aspects are there. You are taking it to 254 perhaps.
No, my lord, I'm not taking it.
Conflict between
There is no law made by the state government.
there is no law made.
Then the question of repugnancy and conflict would arise. My lord, here the principal grievance, actually what happened, my lord, you permit me. From 2019, when these central rules came into force, we have been equipping vehicle in the manufacturer's factory. Suppose a Volvo truck or bus is manufactured. In the factory itself, my equipment is fitted.
Inbuilt and
Inbuilt, because the emphasis is on inbuilt safety devices. This goes back to the manufacturing stage. From 1/1/19, this came into force. As far as the period before 31/12/18 is concerned, vehicles registered before 31/12/18, the states were given the power to decide the date from which compliance will be enforced. So my case, my lord, one limb of my case is from 1/1/19 onwards, my devices are fitted in vehicles. And on 4/4/23, the state has come up with its SOP. Their implementation arrangement started from 15/12/23. Their center was inaugurated from where they would implement this. So vehicles which had my devices fitted, they have been removed on the ground that I am not empaneled with the state. And other devices
prescribed by the state have been
empaneled.
No, it is all prescribed by the center.
Devices procured from vendors empaneled by the state, those have been, my devices have been replaced. So it is a retrospective operation, that is the other ground, my lord, that is there. Therefore, my lord, at the prima facie stage, I wanted to point this out as a consideration from the interim direction may not be passed.
Now, suppose if all that has happened, so far as to the extent it has happened, keep it as it is. Hereafter,
My lords, now he is impaneled in the meantime.
therefore, there is no issue also.
And no issue with him. It is regarding others. Now others say that there is no SOP. Why you will abide by that SOP? That problem now arose for us.
That's heard. Look at the AGM, Mr. Behura, for the appellate stake, and learned counsel representing the respondent on caveat. First time, very many contentions have been raised at the bar. First time, matter is of some significance and of implications. First time, we are of the considered view that matter requires a deeper consideration from all perspectives. First, a prima facie case is made out for grant of interim relief regarding head to the likely consequences of the improved judgment if not kept in abeyance. First, added, the matter has more of policy content, which ordinarily would not belong to the domain of the judiciary. First, in the above circumstances, the application in IA number so and so submitted by affidavit having been favored, there shall be stay of the operation of the improved judgment until further orders. First, call this matter, which date will be convenient? Immediately after summer vacation? Immediately after summer vacation.
Grateful, man.
Item number 4, WPC 5431 of 2026.
That my lord. Appellate number 3 and 4 on segment. I am for the appellate party bank. Appellate party number 4 and 5.
You are for?
You're for the bank.
Lordship. My lordship. Pass over the matter, lordship.
Pass over? No. Your senior is not here.
No, lordship.
All, pass over.
Your lordship is not filing.
Madam is saying
My
something.
lord, 2 is time.
2 weeks time will given, counter has not been
2
filed.
weeks is the request of please to find their counters, if any. Failing which? Science. Next.
Item number 5, WPC 6120 of 2026.
My lord, the order dated 5/2/2026 passed by the Hon'Ble DRAT Kolkata is under challenge, where my lord, the appeal preferred by the respondent opposite party bank is remanded to the DRT for fresh consideration, taking into 2 additional evidence. Where lordship will appreciate, in 2000, my lord, I filed my SARFAESI application, my lord, in 2021.
SARFAESI application.
Was filed, yes, ma'am.
That is.
Was filed on.
You are a banker.
I am the
Borrower.
borrower.
What was the order which you had challenged in SA?
That was the sale notice.
Sale notice. 13/4. 13/2.
13/4 read with 86.
Rule 8.
Rule 8.
Read with 86.
There, my lord, the final order in the SA was passed in 5/12/2020.
That notice is dated.
Sale notice was dated
The sale notice dated 26/11/2021.
26/11/2021.
21. That was disposed of in my favor.
SA number?
My lord, SA number 152 of 2021.
Disposed of on?
That was disposed upon,
Allowed.
that was allowed in my favor on 5/12/2024. On 2 issues.
Impugned order was set aside.
Impugned order was set aside. It was allowed on 2 issue that there is no valuation. 8/5 has not been complied because the property sold was under less valuation, under valuation, and the possession notice was not properly served as per Rule 8(1) and 8(2). Now, my lord, the bank carried an appeal before the Hon'Ble DRAT. There, my lord,
Appeal is called what?
my lord,
DRAT appeal.
DRAT appeal.
appeal.
DRAT appeal.
Appeal.
Nomenclature is that way. Name is that way.
It is a
Appeal
regular
number.
appeal number.
Appeal. So, appeal.
Appeal number?
Appeal number 36 of 2025.
That has remanded the matter for fresh consideration.
Says consideration.
Why order dated?
By the order dated, my lord, 5/2/2026.
5/2/26.
My lord. My respectful submission, this order of remand is not within the domain of the appellate tribunal.
No power to remand at all.
Cannot, because if under the law, the appellate tribunal has to pass the order
Orders on merits.
on merit on 3 issues. My lord, let's glance to provision 20, my lord. Let me take, my lord, to provision 18 of the SARFAESI Act. 18(2).
18 is appeal.
18 is the appeal, my lord. Under
17 is
SARFAESI Act.
DRT.
17 the DRT.
18 is DRAT.
DRT, appeal. My lord, under section 18, the DRT, it is the save or otherwise provided in this act, the appellate tribunal shall, as far as may be, dispose of the appeal in accordance with the provisions of the recovery of debt due to bank, that is the RDB Act, and rules made thereunder.
Under that, what is the scheme?
My lord, let's have a glance to, then it is the parallel to section 20 of the RDB.
DRT Act.
RDB Act, my lord, DRT Act. Because under that, my lord, against order on under 19, appeal has to be prepared. Then, my lord, 20 subsection 4, what it says, on receipt of an appeal under subsection 1 or under subsection 1 of section A1, A1 of the IBC, my lord, the appellate tribunal may, after giving the opposite parties to giving parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying, or setting aside the order appealed against.
Confirming, modifying, or setting aside.
Setting aside.
Remanding is not.
Remanding he can.
How courts, high courts in the country, various high courts in the
Well,
country.
in fact, I saw the last occasion, Lordship, because this issue probably never come up before any constitutional court. I saw the Lord, my lord, I could not get it. I am very sorry on that. On this issue, I could not get any.
Which is the best commentary? We'll ask this question to the persons who are now disturbing below that. Kindly stand up, sir. We are asking you. No, behind you. Sir, you only. We are asking you now. Which is the best commentary on the debt recovery law? We are asking this because you were disturbing. Don't do it. Yes, sir.
My lord, that about my lord.
Questions are not answered. Instead, disturbing the court. Third-year student of law will answer these questions. Yes.
Well, then let's have a glance to express it.
No, we have understood now. It can set aside or it can modify,
Or can allow.
but it cannot remand is your worship.
That is my fault.
What, how, you are for the bank?
My lords, I'm appearing for the bank.
How courts have structured, interpreted this provision, madam?
Unfortunately, I've not had the time to go through this, my lords. If I can get some time. But my lords, I'm looking at the impugned order.
Makes no sense because he has raised a very important point. He is saying, where is the power to remand? Power of a tribunal is what the law gives it to.
My
A
lords,
tribunal
yes, my lords.
cannot transcend the law under which it has been created. Appellate tribunal is also a tribunal. A tribunal has to, because it has no inherent power.
My lords,
Whether it has got inherent power.
No, my lord. Absolutely.
All powers of CPC, but inherent power is not part of CPC.
My lords, there are certain judgments. There's one of the Calcutta High Court also saying that DRT has some power. Unfortunately, I'm just trying to go through it in the morning. I have only one copy, my lords. That's why I was feeling little defending it since there are.
Bank is poor nowadays. State is poor, we can understand.
No,
Bank
my
is
lords.
also poor.
No, my lords. It's my mistake, my lords. I was unwell. I was down with the bad heat stroke.
Sorry, minimum courtesies are not. See, if anybody disturbs, we will ask them questions which will embarrass them. Let the people see what is your quality. I will expose them. Whole public will be watching the performance of you people. Okay. Unfortunately, disturbing persons who disturb are not highlighted here, but we will highlight them.
And this was obviously on the maintainability, paragraph 31, 32, 33.
Maintainability.
Was,
because he has raised a very important question of law.
yes, my lords.
And he also says there is no view available from any of the high courts in the country.
My lords, that I will give me 2 days time. My lords, I'm actually down with a bad heat stroke.
Now,
I left the courtroom yesterday also. Because my lords,
Bank lawyers
if I mean this,
should
there were 2 documents, important documents, which are not part of the record before the DRT. For whatever reason, it was not filed, my lords.
But DRT itself would have decided.
Decided. My lords, if the DRT would have decided, then probably they would have taken the plea that we didn't have time to rebut.
No,
it's a continuation of.
See, you have passes.
It doesn't prejudice us in any manner. Get back on this position. He said
That's
that,
better. You do.
my lords, my lords, keep it to any day.
Understand this. Government lawyers appearing for the banks and public sector undertakings.
Yes, my lords.
We expect their quality to be little higher because you are chosen from the market.
Yes, my lords.
You can't be like
They have not even
any
taken
other.
into consideration Bhakna Motors because auction is already completed, possession given as far as 2022. there are other questions also which will come in. So if either my lords can post it on to Monday or Tuesday on question of law, but if then I'll be in a better position. Because auction is completed, possession handed in 2020.
But let the person who has taken the possession, is he party here?
He is a party, my lord. In fact, he was party in the appeal. He did not contest over there.
Let him not alienate or encumber the property. Let it remain as it is.
Another notice go to them at least. I don't know whether.
Any application is filed.
This is not filed in this matter.
You are only speaking everything. Whether any IA is filed in the matter? No.
No.
Issue emergent notice. First time it is coming.
It was second time. First time, my lord.
You have taken notice.
No matter.
I have solved a copy.
Yes, that's sir.
My
Issue emergent notice. Learned the panel council Srimati so appears for OPs, all OPs.
No, he appears for one.
OP number
I
one.
may take notice to OP number 2.
OP number 2 is the right.
Emergent notice to OP number 2, OP number 2. One sentence about that you are right. Learned counsel appearing for the petitioner very effectively submits that the provisions of section 18 of the SARFAESI Act 2002 do not empower the DRAT in exercising empower DRAT to remand the matter arising from the order of the DRT. First of all, in support of this, he draws our attention to the text of section 18, which takes us to in turn, which is that section DRT.
My lord,
Section?
section 18 of the SARFAESI Act.
SARFAESI Act we have understood.
And
takes us to other act, na?
and 920 of RDB.
Section 20 of RDP Act. RDP Act. First one. OP number 2, OP number 1. Madam appears for OP. Yes, sir. Yes.
Immediately.
Post immediately after service.
Item number 6, WPC 7.
Madam, you have to come with more preparation.
Yes, my lords.
Otherwise,
No, my lords, I'll-
adverse comments in the order itself.
No, my lords.
Item number 6,
Please, your lordship.
Yes.
The petitioner before your lordship is a senior citizen, along with his son, purchased a property, that is a dwelling unit, from the UCO Bank. By
Purchase means in the
auction purchase.
auction buyer.
By auction buyer. So the advertisement for auction was in 10 February 2022. After seeing the notification or the auction notice, he has anticipated and he had declared highest bidder and he has paid 65 lakh 14,090 in March 2022 after the auction over and all money has been paid. Thereafter, bank took 2 years to give the possession, that is in 1st October 2024.
Why?
Because there's some obstruction from the side of the borrower and they took the magistrate for order,
14 order.
district magistrate order, 14 order and then gave the possession. The day when they have gave possession and the lock and key, the purchaser took the key also and the next day when he visited the site, found in the passage there is a wall has been constructed. So he could not able to access the plot or access the house. The reason being that has been done at the instance of the borrower because who is always preventing to do because the road or the passage which is in the name of the borrower has adjacent plot also. So to obstruct, he has created, so time and again, the senior citizen and his son approaching the bank either to give the possession to take some steps. They are saying, no, we have already given the possession, we can do anything. So they ultimately, on the May 2025, so they have replied, we will not able to give and we will also not refund you the money. And he has given a letter, the auction purchase letter March 27 to request to refund my money along with the interest. If I am not getting the house in Bhubaneswar, this is situated in Bhubaneswar. So
So what is the meaning? And as the senior citizen is saying, how much time I will leave also to get my house. So my humble prayer for your lordship, the issue notice why they will not give the money refunded to me, because they have not disclosed the passage which they have constructed the wall is not giving any passage to the auction purchaser. In good faith, he has purchased. It has violated, my lord, this section 55 of the TP Act in the first provision. I will not see, I will read it. How it is a material defect.
Duty of the seller.
Seller, that is caveat venditor. Caveat venditor means he has to inform if there is a material defect therein. If the passage...
When possession was given to you?
Possession was given to 1st October 2024.
1 second. Did you go there?
Yes. And before that, because there was a road. I will just
answer, sir.
Answer some question. Answer our question.
He went there, my lord.
He went there.
Went there.
When he went there, he opened the keys. What door lock was open?
What happened? The police, through police, they have given they have break open and they have put the lock and given the key to the auction purchaser.
But you opened the lock.
Thereafter,
we are asking you, you are not answering.
My lord.
Then you have to dismiss your petition.
No, my lord.
Because you are not answering the court's question.
No, my lord.
Yeah. Did you open the lock using the key? Did you open the doors?
We have opened the doors. Right there. Okay, my lord.
After opening the doors, did you step into the house?
We have stepped into the house and...
Did you walk over the house?
My lord, walk over the house and seen the entire house, my lord.
At that time, whether there was a wall?
No.
Then what can be done?
Passage was only passage, my lord. What I'm saying, the passage which has not been declared that this passage, where it is in a private passage, and this passage which is saying that this is a public passage and you can go and use it. But when then we put lock and key and come back, and next day we'll go for the house, we find that there is a big wall. They have constructed.
Go to civil court.
No, my lord, what I'm saying,
as on the date they gave possession to you,
my lord,
there was no wall.
No, in the possession, it is a fact. There is no wall. But what I am saying...
Why can't you listen to us?
Have
you read the Nelson on injunctions? You have not read. By your argument, I can make out.
Millard?
Nelson on injunctions. Beautiful book is read. Since you have not read that book, all these arguments you are making before the court. Nelson says, once the seller, which you have read, section 55, 54 defines what is sales for the transfer of property. 55 gives duties of the seller before sale deed, duties of the seller after the sale deed, duties of the buyer before and after the sale. Then Mullah has given a very good chart on that. But Nelson reference to that says, once the seller puts you in possession,
as is, where is basis?
That apart as is varies because Apex Code 2018 is you went there, there was no wall. Wall is constructed all of a sudden.
All of a sudden.
Maybe by the owner of the ex-owner of the property. For that, the remedy is before the civil court.
I'll just read out a recent Supreme Court judgment, Delhi Development Authority versus Corporation Bank. So, your lordship, so in
2 copies are there.
2 copies are there.
Then we look at it. Otherwise, we will not share our judgment with each other.
Your lordship. Para 31. I have underlined. Your lordship kindly see and
no, that's a different question. That was not the question. See, as on the date you took possession, wall was not there.
Wall was not there.
The wall between heaven and the hell is built up by somebody. You should catch that man.
Milord, because the adjacent plot is, your lordship kindly my annex
How can we decide
petition.
all this?
No. Well, equitable grant, milord, is a dwelling unit. I have purchased. My only submission is let them notice be issued and come and say actually when they have handed over me, whether they are aware about the passage, public passage were there or not. What my submission, milord, that is a suppression of material fact, which in good faith I am not able to know, because every time I went, I have inspected, the road is there, but that road is a private road, it is not a public road, and which has been in the name of the borrower, and ultimately borrower prevented me, and then because why they have took 2 years, because always the borrower is preventing, but ultimately took the help of the police. So
Take
only,
notice, let us. Take notice what the borrower, you have made the borrower a party.
I have not made the borrower party.
Make him a party. Petitioner is directed to arrange.
Which party now? Borrower has already made one party.
So made party.
Milord. Party 3 and 4, milord. Borrower and guarantor both.
Issue emergent notice. You are for the bank?
Milord.
Learned panel council on our request accepts notice for the OP bank 1 and 2. 1 and 2. OPs 1 and 2. Emergent notice to 3 and 4.
3 and 4.
3 and 4. Returnable within 2 weeks.
So copy, sorry.
May I submit one thing?
Yes.
But now, my lord, the borrower has failed, my lord, before the DRT. SA was dismissed. And against that, my lord, the appeal is pending before the DRT. And notice has been issued to the bank as well as the auction purchaser, and they have appealed.
You were before the auction purchaser. That was borrower's
Borrower's appeal. And
what he should do with this? Let us see. Yes, let us see. To take this as on the date you are giving to it. See, when judges want to know, you have to listen to them because something will be required for us. We have no personal interest in this matter. But office has to discharge this duty. Na? For that, you should permit us what the judge is saying. That is the argument. What judge thinks, this Oliver Wendell Holmes used to say. Law is what judge thinks it to be. Therefore, judge's perception, you have to catch first. Then you should address. Yes. Yes.
Item number 7, WPC 7895 of 2026.
May I please? This is the order against the Central Election Tribunal Kotak Cutter.
Yeah?
Central Administrative Tribunal Kotak Cutter.
Central Administrative
Tribunal.
CAT.
And it's 8 page 127, Your Lordship. It's a fact that, Your Lordship, while the applicant petitioner was working as peon, notification was issued for the Group C for LDC examination.
You need Group D.
Group D now.
Then this Group D, LDC, Group C was advertised.
In 2017. 2018, the result was published. But my name is not there. That's why I sought for information through RTI Act to serve me the copies of the answer scripts, Your Lordship. They have not given, Your Lordship. Subsequent RTI has not been supplied. I have made representation that is in a wrong, that is IRCON, which is my right answer. They have not given me, Your Lordship. And some sorts of copies of the papers have not been supplied, Your Lordship.
But you secured 49 out of 50.
49. But IRCON is right. So that's why they've been categorically stated in counter that qualified mark is 50. And for your secured 49, that's why not qualified. But IRCON, Your Lordship, kindly see, I have page 91, Your Lordship.
Go to 91.
91, sir. Book I have annexed in my MA, Your Lordship. Page 91, sir. Railway establishment rules.
24.
91, sir. Yes, sir. 24.
24.
Yes, sir. Indian Railways Construction Company Limited, Lordship. And Your Lordship, my answer script, Your Lordship, can I see?
Answer is number, which one? ABCD?
Yes, Lordship. Page 97. Page 97, sir. 97, sir. Number 6, serial number 4. IRCON, Your Lordship. Given me 0, Your Lordship.
Take notice. You take notice.
Yes, Lordship.
Issue emergent notice.
Obliged.
So your central government who appears for?
My lord, in this case, I am acting for the local
Learned senior panel ones?
No, my lord, CGC.
Learned CGC Shri
So, whether from the doctors.
accepts notice for OP numbers 1 to 5. First of notice to 6 is dismissed. Matter lies in a narrow person. Would call you first immediately after summer vacation. Yes. I have not given any market on to. Great question. One again, we want to give. Then people open is for things that they don't do all that. They won't. Yes, we'll revert in a couple of minutes. This is
Item number 8, WPC 8461 of 2026.
8.
May I please, Your Lordship? That the present petitioner challenging a possession notice dated 7/10/2024. 7/10/2024, my lord.
7/10/2024.
My lord. That is an annexure 1, my lord. Across this honorable court, my lord, there is a total outstanding of rupees 19,43,000 and some odd amounts.
How much?
19 lakhs 767.
About 20.
Mine.
About 20 lakhs.
About
19.5.
19. As on?
My lord,
7/10/24.
7/10/24.
Then it will be much more now.
My lord, the possession within the meantime, the present petitioner already deposited a sum of rupees 2.5 lakhs in the date of September 2025, my lord, and given a notice for OTS proposal, given a proposal for the OTS, and they are not considering the same, and the present petitioner approaching
Who appears for the bank? Is it a housing loan?
Housing loan, my lord.
What your client is doing?
He is a LIC agent.
And his wife is doing what?
A housewife.
Housewife.
Mine.
But this also they could have deposits. You deposit some amount. How much you will deposit?
So, outstanding 25% of the outstanding amount.
That's good. Take one. What's your name?
Agni Shikharai.
Agni, learned counsel Agni Shikhara.
Agni Shikharai.
Shikharai, appearing for the petitioner borrower vehemently submits that as on 7/10/2024, about 19.5 lakh was outstanding in respect of a housing loan. First off, in September 2025, petitioner has credited a sum of rupees 2.5 lakh to the loan account. First off, there was some financial difficulty which borrower was facing, and therefore much debt servicing could not be done, and that now he is ready and willing to go for OTS, and to show bona fide, he would credit 25% of the outstanding amount to the loan account in question. If a reasonable ease according. First off, matter requires due consideration, examination, and a case is made out for issuance of emergent notice and grant of reprieve. First off. Next one, in the above circumstances, the application in IA number 5012 of 2026, supported by affidavit, having been favored all coercive proceedings are halted, subject to petitioner depositing 25% of the outstanding amount as at 10% in 2 weeks, another 10% in 2 more weeks, and the remainder in 1 week.
Are you sure that this is a housing loan?
My lord, this is a
Working
private
capital?
private finance.
No,
So
they speak about working capital. How can there be working capital in housing? There is not housing loan.
as per the instruction, this is a private
The
finance.
document itself says, no,
It's a
whatever
working
be the
capital.
infraction.
And you have hypothecated the assets and you have hypothecated the assets.
Not housing loan.
The purpose,
Papers you should not make.
my lord, that for the purpose of housing,
But,
might be it is a cap.
This is what is written in your bank paper which you have filed.
Non-finance. Anyway, within 5 weeks, she has to deposit. Yeah. Petitioner is put to warning that in the event this facility is not availed, the interim order stands rescinded, and also petition runs the risk of dismissal on that ground per se. Okay. Next.
Item number 9, WBC 8965 of 2020.
May I please?
Yes.
The answer 9, the auction sale notice dated 25 to 2026 is under challenge lawsuit.
Which notice?
Notice 25 to 2026, that is auction sale notice lawsuit.
Auction notice.
My lord. The date of auction is scheduled to be on 30th March lawsuit.
30th. How much money is outstanding?
The outstanding is, as per notice, 10,61,294.
What loan it is?
With the housing loan.
Housing loan.
My lord.
10 lakh?
10,61,294.
As on?
As on 24 to 2026. That is in notice sellers. Page 95. Last paragraph.
25%. You pay 25%.
Mine.
You heard the counsel for the petitioner. It is a housing loan, present outstanding being 10,61,294, which has eventually resulted into shooting of possession notice. Possession notice?
Yes. Auction notice.
Auction notice. Dated?
Auction notice 25 to 2026.
February 2026. First, counsel for the petitioner submits that some efforts are being made to organize amount for repayment of the loan. And if reprieve is granted, that would be rectified. First, he very fairly submits that his client would deposit 25% of the outstanding amount if easy installments are indicated. First off, we agree with this view. In the above circumstances, application in my number so having been favored, the coercive proceedings are stayed. Coercive proceedings of loan recovery are stayed, subject to petitioner depositing 25% of the amount as at crediting to the loan account as at 10% in 2 weeks, another 10% 2 weeks, remainder in 1 week next following, failing which issuing.
Item number 10, WPC 9242 of 2026.
May it please, Lord.
Yes.
Matter related to situation dispute, my lord. Here, my lord, I am challenging the letter dated 17/3/2026, that is at Annexure 4, page 55. 17/3/2026.
What is that?
My lord, here, my lord, the opposite party has asked me to vacate the premises within 7 days. failing which they will take step to evict me with the help of the competent authority. Here, my lord, the history is who was my lord. Here, my lord, I have against the measures taken, I had already filed a SARFAESI application before the DRT cutter under section 17 of the Act. There I my lord, SA number
161 of 20.
161 of 2022. That was filed on 22.
Against what order?
Against the order under section 14 of the Act, my lord, DM's order. Inter alia, I challenge all the proceedings and measures initiated under the Act. Well, that has not favored me. That was dismissed against me.
Dismissed on?
That was dismissed, my lord, 7/2/2025.
Any DRT?
My lord, I preferred an appeal before the DRT on 17/2/2000.
Appeal number?
My lord, appeal number 27 of 2020.
What happened to that?
My lord, the Hon'Ble DRT remanded the matter with
Same question will arise.
My lord. No, my lord, I am not raising here the same question because my
Remand on?
But it was remanded on 19/12/2025. December କେମିତି ଅର୍ଡର ହବ ଆଜ୍ଞା? 25 ଡିସେମ୍ବର ତ ଛୁଟି ଥାଏ. 19/12/2025 annexure 2 page 41.
Now, then.
My lord, now the matter is pending.
You make application before the DRT in that pending essay.
Lord, may allow me to, I'll file it today. In fact, I have prepared.
No, that court is not the right remedy.
My lord. But till, my lord, the essay is taken up, the IA is taken up, I may
protect. For that one, we will not do that. Essay is pending. How we can
essay is pending till the IA is taken up at least for 1 week. Because
no, we will not.
The problem may
you have to vacate that. Problem will be you have to vacate. What to?
Tomorrow DRT is not functioning.
Yesterday it was functioning. Today it was functioning. Instead of going there, you have gone to some other place. What should happen? We will not grant that way. Once if we grant, it becomes a right for others. They will ask, you have given relief to that man. Why not to me?
I am ready. In fact, Lordship will appreciate during the essay.
How much money is
well, it is this small amount, 23,22,395 the demand amount.
You pay 50% of the amount, we will stay this.
Lordship, allow me some time because my amount is with the DRT, the pre-deposit. I can get it back.
How much money?
My lord, Lordship have glanced ahead by that is
how much money?
13,50,000 it is with the DRT as a pre-deposit. 13,50,000 is there, my lord. I am taking step to refund.
No, we'll direct the DRT to put that money into your loan account.
And it is property has been sold since long.
It is sold already.
Yes, no. Third party right has been created. The auction process is there. I would say my learned friend has filed the petition there. I will assure him that within 10 days, nothing will be happen to him.
But within 10 days, when I was practical, he knows. I grateful to his
direct the DRT decide the matter because the DRT has directed within 2 months. We are facing problem.
We are facing problem.
Both of us because it is assigned to another advocate who is now ill. For that reason, I am conducting the case on behalf of him. I want to finish the case. He wants to finish this case also because DRT has remanded on 2 issues. Only that 2 issues will be decided. It can be decided in one day, my lord.
Remanded.
I assure before your lordship, within 10 days, nothing will happen to my brother also, to his client also.
At least 15 days because next week you are covering a maximum days of holiday. Next week you are covering maximum days of holiday. At least 15 days, if my lord and is so generous.
My client,
Let it be
very gracious.
I am grateful to him, my lord, and he has been cooperating all the time.
Both the sides having argued the matter for some time. Now I agree with the suggestion of this court that the petitioner should be permitted to file an application in pending essay number 161 of 2023 in respect of grievance sought to be worked out at the hands of the court against the letter dated
17/3/2026.
17/3/2026, comma, keeping open all contentions of the parties. And that till and that to enable the same, the parties shall maintain status quo.
And that means my submission may be recorded, madam. Because if
we
one,
are protecting you.
No, not necessarily.
No. What we are saying is, we are telling this to you, and you agreed with this.
This is
so that instead of you giving undertaking.
Yes, ma'am.
Understand. And that to facilitate the same, the party shall maintain status quo for a period of 2 weeks, 10 days. Status quo you maintain. That's all. We will not say put in possession, protect in possession. We do not know what has happened.
One more, Your Lordship, direct. Since
that the essay itself shall be heard and decided within an outer limit of 4 weeks.
Already 2 months gone. TRT
4 weeks we are giving.
4 weeks.
Yes, ma'am.
Ordered accordingly, and writ petition is this. Yes. Okay.
Item number 11, OJC 14746 of 1999.
29. Nobody is coming. Oh.
Is it surviving anyway?
You see, Mandi is there. He was arguing
To send the court notice to them. We are told at the bar that Mr. S.K. Patnaik, but there is US
regularly coming. That engineering matter he was to assist your lordship.
But
let it be pass over.
That's good. Pass over.
Item number 12, Writ Appeal B422 of 2024.
12.
Hello. I am for the respondents. Your Lordship passed similar order in WA number 340.
Covered by judgment.
No,
it is not covered.
Your Lordship issue notice and condone the delay subject to payment of cost.
What is this matter?
This matter is, my lord, these petitioners were appointed in the year 2007.
2007.
In response to the advertisement made in the year 1995. 1905 to 1995, an advertisement was made for the post of junior clerk.
Yes.
My lord, thereafter...
How many?
There were many
vacancies.
The vacancies are there. My lord, in the year 2000, 7/1/2000, the merit list was published, select list was published.
7/1/2000. 2000.
Select list was published. There are some cases pending. Litigations were pending. My lord, this petitioner got appointment on 8/3/2007. Some got appointment before 2005. 1/1/2005.
Only one person. There are so many people, na?
So many people are there.
All they were appointed in 2007. Okay.
Now, my lord, these people, candidates are claiming that they should come under the old pension rule of 1992 and the GPF Act of 1938. They wanted to come under the Act.
1/1/2005 is the date of repeal.
My lord,
1/1/2005. But we extended period that 1/9
only September, till September.
till September. So even then it does not cover the point is this one.
Exactly, my lord.
What the learned single judge says?
Single judge says, your lordship may kindly have a turn to annexure 16. No, sorry. Annexure 1 of page 19, your lordship may kindly say. Para 16. Be that as it may, in view of the admitted position with regard to the selection.
Select list is 7/1/2000.
2000.
That is the reason learned para 16. It appears to be correct.
Yes. Para 16, it is they have submitted there. The vacancy is available in respect of so and so and passed on so and so. That's why
it will date back to that day. That they have no case at all.
That's why the online single judge has directed.
My lord, he has correctly done that.
My lord, lordship, yes, lordship may kindly a pension rule ta delo re.
Give that pension rules.
No, pension rule your lordship may kindly have.
But because advertisement is of 1995.
Yes.
And the appointment is the select list is January 2000.
January 2000.
Appointment
And
is
the appointment
that goes in terms of that.
No, my lord, your lordship.
The single judge has said that.
Yes.
No, this is
Lordship may kindly have a look to Rule 3.
Rule 3.
Rule 3 of the pension rule. Rule 3, sub-rule 4. Can I place my?
Notwithstanding anything
contained in these rules, all persons appointed under the government of Odisha with effect from 1st day of January 2005 shall not be eligible for pension as defined under sub-rule 1 of Rule 3 of the said rule, but shall be covered under
defined contribution pension scheme
as specified below. Because there was no, these people are not appointed before 1st January 2005. It is my contention that they will not come under pension.
First 2005 already. Within what period? Once select list is prepared and sent to you for operation, within what period you should do that? If you keep it for 5 years pending, what is the fault of the candidate, the selected candidate?
Unless and until they come over, they will join in the government, but they are not the holder of the government post.
Correct.
Age on date.
For your fault. Why they should suffer? What is the period prescribed for issuance of appointment order once the select list is done? Then within reasonable time. That's how courts have held. If you have not done your job, how can you take the benefit of your fault? No, we will not agree with it. This has to be read that way. Provided, see, notwithstanding anything contained in the rules, all persons appointed under government of Odisha means who ought to have been appointed within the reasonable time. Otherwise, you will sleep over that select list. Eventually, the candidates would be affected. For your fault, you cannot take the benefit. Why did you keep the 2000 select list, January 2000 select list?
Because of the operation. Because of the litigations.
But was he one of the applicant anywhere for which the matter has been stalled? The appointment was stalled.
No,
Has he any contribution to that?
No. How can you?
If he was
that
one of
man,
the
for your lapses, no, we do not agree with you. The learned single judge, he has rightly said 7/1/2000 was the date of para 16. Select list is under annexure 2 on 7/1/2000. Vacancies available in respect of general male candidate as reflected on annexure 1 and other order passed by the learned tribunal in the aforementioned case. The petitioner's claim for his inclusion under the provisions of CCS pension rules 1992. The GF4 rules 1918 needs favorable consideration.
It is not that simply a process of selection has started.
No.
It has ended by select list.
Correct.
My lord, that's it.
And appointment has been issued subsequent.
Subsequently,
that will take back to this one for pension.
The relation back.
Otherwise, what happens? I will tell you. You will start the selection process. You will direct the OPSC to start the selection process. They prepare the select list.
Then stop it.
Then after sending select list to UPSC, OPSC will have no control over the government. It cannot obviously.
Yes.
And your people, maybe elections will come, next government will come. Before this should happen, should not happen, these things begin. There is one judgment mentioning about this. Karnataka High Court has mentioned about this. Therefore, for your lapse, you cannot keep the select list pending at your whims and fancies under the pillow cover. We don't agree with that. If select list is, where are the UPSC rules, the rules of recruitment? Within what period? Generally, there will be. Within what period?
Generally, within 1 year. Merit list is valid for
Within 1 year.
1 year.
Had you given it within 1 year, in January 2001, they would have been in appointment.
Exactly.
Which is that rule? Within 1 year rule, kindly give it. The very object of rule of law is to minimize the discretions.
Yes.
As far as possible.
That's it.
Man being what he is. This one, that is not what is it, as you rightly said, what is his contribution to the litigation? Right now. Respondent employees WPC number 21936 of 2022 came to be allowed by the learned single judge wide order dated 7/9/2022, granting him the benefit of OCS pension rules 1992 and the GPFO rules 1938. First one. Para 16 and 17 of the order read as at next paragraph. Next paragraph. Another paragraph. State and its functionaries have preferred appeal against the above order, specifically taking up a contention that under sub-rule 3 of rule 3 of the pension rules, the question of granting pensionary benefit would arise only on the candidates being appointed under the government.
Sub-rule 4.
Sub-rule 4. Sub-rule
4 only.
3. 4 of 3.
4 of rule 3.
First one. This aspect having been lost sight of by the learned single judge, Mr. G submit, AGA Mr. G submits, interference of this court is eminently warranted. First one. Learned counsel representing the employee, respondent employee, resists the intra-court appeal, making submission in justification of the impugned order, and the reasoning at paragraphs 16 and 17, culled above, on which it has been constructed. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge, specifically at paragraph 16 and 17. First one. To that we add, we were inclined to, to that we add that under the recruitment rules, which here, extant recruitment rules, the select list will be valid for a period of ordinarily for a period of 1 year. The advertisement pursuant to advertisement dated advertisement of 1995, the select list was prepared on 7/1/2000 and sent to the government for operation. First off. However, government slept over the same for a period of 7 years. First off, no plausible explanation is forthcoming for keeping the select list in limbo for such a long period, especially when the validity of select list itself is 1 year. First off, assuming that within 1 year the select list could have been operated, the cutoff date of 1/9/2005.
1/1/2005, published in September 2005.
That is 1/9. That 1/9/2005. What you are written? What sentence? What sentence? No. Was 1 year. First one. Next one. Next person. Ours being a model and welfare state as ordained by the Constitution of India, the authorities, howsoever high they may be, have to act in accordance with law. First of all, no plausible explanation is offered as to why for 7 long years the appointment orders were not issued to these poor respondents. First of all, granting relief to the appellant's hearing would virtually amount to placing premium on complacency of the officers, to say the least. And therefore it cannot be. First, in the above circumstances, these appeals are liable to be dismissed, and accordingly they are, courts having been made easy. First, impugned order of the learned single, common order it is.
It is common order.
Impugned order of the learned single judge shall be implemented in letter and spirit within an outer limit of 3 months without giving scope for contempt action. Yes, take this. Just give me the rule which says 1 year.
I'm giving
the name of that is add that.
This is only one. Writ petition, how many writ petitions? This relates to only Tapan Kumar Saab.
All
common order. Common order.
No, common order.
Individual order.
All are same.
Then rest of the matters, the subject matter of this appeal is substantially similar to the one in writ appeal number 3422 of 2024, which you have dismissed this day by a reasoned order. Okay, therefore, this appeal is also dismissed. Like this, you should write it to the with the same terms and conditions. All right, one more ground you have to add that one. The earlier one, writ appeal 3422. Added to the above, one more ground. Added to the above, the appeal has been filed after brooking a long delay of 804 days. First one, an application supported by affidavit in IA number 8802 of 2024 has been preferred, seeking its condonation. First one, a perusal of the same does not convince us that any plausible explanation is offered for such condonation. First up, the text appears to be parrot-like. First up, therefore, application is also for condonation of delay is also rejected. Okay.
Simple.
See, in rest of the matter, sir, number of days 700, 900.
Only the days will change.
Days will go. You can make the same one as it is. Okay. Only thing is order date will change. What about?
Item number 13, Rate Application 1447 of 2025.
Yes.
Yes, my lord. Similar matter has already been decided by your lordship.
That replacement matter.
Yes.
Authored by Justice Das, Honorable Justice Das. My lord, I am appearing for a respondent number 3 municipality.
Respondent number 3.
3 municipality.
Go to the state and its the state.
Yes, state, my lord.
Is in state in this intra-court appeal seeks to call in question a learned single judge's order 28 dated 28/3/2025, whereby respondent employees WPC number 30090 of 2021 having been favored, relief has been accorded to him or her?
Him.
To him.
Him.
As under para 13. Yes. Next paragraph. After turning the pages of the appeal paper book, and after hearing learned advocates appearing for the parties, we notice that the subject matter of this appeal is substantially similar to the one in writ appeal number 1102 of 2025 between State of Odisha versus Jaya Krishna Senapati, disposed of by us, while order dated 19/1/2026, whereby appeal of the kind has been dismissed. After referring to latest decision of the apex court in Chago,
Para 8 and 9 of the judgment.
whereas 8 and 9 of Chago.
No. Judgment. The judgment is lordship referring. Of your lordship judgment. Taken care of in para 9.
Maybe first. How any delays or preferred?
16 days.
Sir, my lord, 1161.
No delay. Next paragraph.
No, 116.
The above apart, we also notice a long delay of 116 days in preferring the appeal, for the condonation of which application in IA number 3732 of 2025, supported by affidavit, is preferred. First step. We go to application. We do not fail to notice that even here the explanation offered is very casual, and that is not plausible by any standards. And that cannot be considered as being plausible explanation by any standards. First of all, therefore, application is also rejected. First of all. Then, other things.
My lord, I have a small prayer. I have a small prayer. The petition is going to return on 31/3/2026. This
one. Yes, ma'am. Since our petitioner is our respondent employee is going to attain going to demit the office on attaining the age of superannuation in
31/3/2026
on 31/3.
my lord.
31
This month,
what can be
This month, my lord.
31/3/2026, comma, the order of the learned single judge shall be given effect to within an outer limit of 4 weeks. Only this one, Jago, 4 weeks. So that all terminal benefits are accordingly determined.
Deeply.
Item number 14.
Take this.
Item 14, my lord.
Yes.
It's a state appeal.
Ah.
They are challenging the order passed on 3/5/2025. The crux of the point is the person was in service attaining the age of superannuation retired since 39/2007.
39/2007.
While he was in service, vigilance case was there, This proportional 13.
What is the relief granted to him now?
My lord, they have preferred the appeal and the imprisonment was 2 years, my lord, conviction with 10,000. And for that period, they have been allowed the pension, my lord. Provisional pension. Our ground of challenge is, my lord,
once convicted, he is not entitled.
Section 7, my lord. And that apart, my lord, that the judgment of K.C. Sarin is squarely covered.
What Sarin says? Did you tell it to the learned single judge?
Section 7 we have submitted. Can have a glance to 7.
Withhold or withdrawal?
Right of the government to withhold the
Withhold or withdraw?
withdraw the pension. 7.1. It is clear.
This judgment was not withheld.
This came subsequently.
No, judgment is of 2001.
2001. But learned single judge appeal takes its own time for whether that judgment and conviction and sentencing, sentence, both are state?
No, my lord, not state.
Not state.
Not state. That would have taken the
If they are state, then a different Sidhu, Navjot Singh Sidhu versus
versus state of Punjab.
State of Punjab.
But here it is squarely covered by the K.C. Sarin. And 7 is a rider, my lord.
What it
The
says?
government, my lord, may I read it? The government reserves the
Power to
excel right to withhold a pension or gratuity or both either in full or part or withdrawing a pension in full or part were permanently or for a specified period and of the ordering recovery of a pension or gratuity of the whole part or any pecuniary loss
if
caused
he is found gross misconduct to negligence,
negligent duty and during the period of service, including the
But where is the criminal conviction?
Here, my lord. Here is the
7.1 speaks of civil consequences.
Yes, ma'am.
Where is the, if he is convicted, he shall not be given pension. Where is that section? There is any provision?
Yes.
Rule 6 of the pension.
Rule 6 and Rule 66 also.
There must be. For disciplinary inquiry, if it can be withheld. For conviction also it has to be.
Conviction.
Future good conduct.
Pension is subject. Rules 6.
No, where is the conviction? Section 6, Rule 66.
66. Oh, 6.
6 is a future good conduct.
6.2.
6.2?
Yes, 6.2. Last line. Pension sanctioning authority may by order writing. If the pensioner is
convicted of a serious
crime
and is found guilty of grave misconduct. No such charge shall be brought by an authority. The owner to be competent to move from to the court, held by the pensioner immediately before the retirement from service, provided for that what a pension is cannot be done, the amount of pension shall not be reduced. But learned single judge has said, now appeal has been filed. Is there any interim order?
No, madam.
Where, what is that appeal number? You take
Appeal number is
number 775 of 2023. Go to criminal appeal number 775.
CRLA
Is there any
775 of 2023.
There must be some interim order, otherwise you would not have passed that order. Is that? Appeal per se does not result into automatic suspension of the conviction order. Order of
Fine and suspension of the sentence. These are two
there have
separate
to be.
things.
No, not only suspension of sentence. Conviction has to be stayed. Apex court says,
It is not that.
in Navjot Singh Sidhu, the same issue was considered. Go to that, see if any order is there.
775 of 2023.
Any interim order is there? Wait, what was the misconduct? What was the offense involved?
This is my letter. 13 to 13
PC Act.
Of PC Act 88.
Yes. 409, 468, 471.
Then PC Act offenses are offenses involving moral turpitude. Therefore, they are not susceptible to PO Act and plea bargaining also. Right? Any interim order? Criminal appeal number so and so heard, admitted. All for the records. Ground the property, ground the price, the open is heard, it is applicable normally. The ground permitted that if is information requirements, there are the ground association, federal and state procedure of the system. Relation of fine amount, but it was notice I have gone to other side. No, you take notice. You took notice. There are arguable points in this. Though matter now the judge said because there is already interim order also there in the criminal matter.
No, yeah.
There is interim order.
Conviction is not stated.
Conviction is not stated. That's what that aspect.
It is so far this 10,000 is fine.
Realization of fine.
Realization as a fine.
And you have granted bail.
You take notice. Notice is not yet ordered. Issue emergent notice. Returnable within 6 weeks. Yes. Otherwise, all for convicts also you have to give pension.
At that interim order, because they are pursuing the content person, it is posted to day after minute.
Looking at the AGA 26 drawing attention of our attention to the provisions of Rule 6 of pension rules 1992.
Yes, ma'am.
Yes, 1992 submits that once an employee is convicted for an offense involving moral turpitude, the government can withhold the pension, and therefore this aspect having not been rightly discussed by the discussed in the right perspective by the learned single judge, the same needs to be the impugned order needs to be stayed. First, he also tells us that the impugned order has a lot of mischief potential in as much as the class of employees who have been convicted but only admitted to bail may seek the same benefit on the principle of parity, there being no stay of conviction itself in the light of apex court decision in Navjot Singh Sidhu versus so in Delhi.
State of Punjab.
Punjab it is. Fine. So put there is force in this submission. Next paragraph. In the above circumstances, this the impugned order, the subject application. Where is your application for day?
Yes.
One donation is there. 421. Application in IA number 4218 supported 2025 having been favored. There shall be stay of the impugned order until further orders. You can say that shall be stay of the impugned order. Okay. Let notice go. Okay. Issue notice on main matter and delay application. Okay. No more process. Yes.
Item number 15, read application 2028 of 2025.
Let's take this matter on some other date.
3 weeks. That's the request.
Item number 17, EWPC 5531 of 2026.
PWC diary. No, it is 16 is over. 16 is 17.
You can say up to 2 weeks.
2 weeks. 17, no?
Yes.
Chennai Small Finance Bank Limited. Who? Lajima court order has not been this was dismissed for the prosecution. You that order, Lajima order is that particular. It has to be from the court. Office objections to be addressed within 2 weeks, filling which petition runs the risk of dismissal or non-prosecution. Okay. Yes, sir, just I call you that advocate and inform him that you have passed this order.
Item number 19, WPC 15871 of 2014.
19. Management of Messrs.
Sir, we are actually waiting.
Yes, he has come now. You took up his name and he is here already.
Sorry, Mr. Mohanty is also difficult because of some problem.
Indeed.
He has not come, yes. But we in fact discussed both of them. We suggested one amount for each of the workmen. That is 1 lakh rupees, I tell you. But my
1 lakh.
1 lakh. Because taking into consideration that we said that we will talk to management.
I'll have 2 years because I'm not committed. So may give some time. 10 to 15 minutes.
Let the report be filed.
Report.
Right? That will be recorded. It can be recorded. I don't know.
Yes, sir. Speaking of record,
Otherwise,
No, we'll call this matter someday. Yes, meanwhile the things.
in the meantime, I'll text it.
yes, yes.
Call this matter on 22nd April.
22nd year.
No problem. Mr. Roth?
Yes,
Yes.
It's
Call me. Next.
Item number 20, WPC 20856 of 2014.
14. Minor. It is a case of removal, my lord. So after 19 years of service, so during his tenure of service, petitioner's husband, he was hospitalized in the railway hospital due to brain epilepsy. And the file was under process to give him the compulsory retirement, so premature retirement, voluntary retirement, as admissible under the railway pension rule. So due to shortfall of certain period, because 20 years required, so due to shortfall period, he was not given the retirement. So after that, my lord, she and due to brain stroke, my lord, he could not attend the service. Thereafter, without any proper inquiry, when the file was under process to give him voluntary retirement, page 3098, in the year 98, my lord, the 2000 annexure 15, page 48, he was removed from service.
Removed on the ground of unauthorized absence.
Unauthorized absence. So only after, my lord, thereafter he died. I approached the tribunal.
I means widow approached the tribunal.
Would approach the tribunal to give the terminal benefits. So by that time they, my lord, took the only the ground, the personal file is not traceable. So I approached, so I obtained the documents through RTI. So in RTI process, they supplied all documents, service book, removal order under annexure 15.
How long you remained unauthorizedly absent?
Well, at 98 to 2000.
Full date you have to give. We are dead against giving the years.
Yes, ma'am.
We are fed up with that actually.
My lord, 9798 to 9798. So 192000. The details given in page 48, annexure 15.
He remained absent.
Absent due to the mental.
No, that you could have informed. I am not well and I can't come.
Yes, madam. Because in the railway hospital, so they when they were processed.
You were hospitalized for how long?
My lord, for 95 to 98.
Again, year only.
Well,
give the date.
Yes, my lord.
Date on which he got admitted in hospital and was discharged.
My lord, 87, 98.
8798.
98. Two, my lord. Till the date of removal. 16, date of removal. 10/9/2000.
10/9/2000. You said 1/9/2000.
10/9/2000.
In a railway hospital he was or in some other hospital?
Railway hospital. So, I am reading, my lord, with page 30, the order of the senior DPO with reference to your above mentioned memo, A.K. Adhikari, petitioner's, my lord, husband, Store Khalasi, was admitted to this hospital. He is on cured to scalp injury but suffering from mental illness. As none of his relatives are available with him for advice regarding further treatment of mental illness, you are requested to arrange two escorts. He is to be referred to the senior DMO, psychiatric, SCB Medical College Hospital for treatment as advised by senior surgeon, as it is not safe to treat him in the general ward. He is being discharged from the hospital with advice to attend the, my lord, the for further disposal. This is for information necessary action. So this is a letter, page 30, communicated by senior DPO to the senior DME. Thereafter, my lord, the
Page
You were discharged on 8799 itself, 98 itself.
98.
Yes. Afterwards, where did he go?
So, my lord, thereafter, he remained on treatment at my lord, water, my lord. Because nobody was there, because it is advised that two male members shall be escorted to carry him to the SC Medical College Hospital. So, no male member was there to attend him. So, he remained in the water, my lord, only being confined.
What is the disease?
My lord?
Well, is it schizophrenia?
Oh, yes,
or
ma'am.
which what
Scalp injury. It is reported in the scalp injury.
Scalp injury is a physical injury.
Physical injury.
The effect of that is mental injury.
Mental injury.
What is that mental ailment?
So mental ailment, my lord, the exact
scalp injury happened during the course of the employment or not connected with employment. Suppose if he goes for drinks and takes excessive drinks. And
no, ma'am, because he was a store khalasi, it is out of employment. So that is why I understand.
Out of employment during the course of employment. That way, there should be nexus between discharge of his duties and the injury he suffers.
Right.
Only then what you say is correct. Suppose if that person goes for robbery, and he is attacked. Give an example.
Yes, my lord. So no records. In fact, no records are available. While he was in Bilaspur division in the Central Railway, so by that time the mental illness aggravated. For that reason, he was transferred to Khurda Railway Division because he belongs to the native district nearby, the Khurda Road. So on that ground, he was also hospitalized at Bilaspur. So in the present, the letter of 1980, he was, after his hospitalization in railway hospital, there was no specific specialization in the mental psychiatric. So he was advised to go for treatment by the SC Medical College. So while it was recurring, again the senior section engineer moved the file to the DRM on 9/7/98 to give him voluntary retirement. So due to shortfall of certain period.
What is the shortfall?
Yes, ma'am.
By the time he has not completed 20 years of service.
What is the shortfall?
Shortfall, my lord, is not.
It says around 19 years, 7 months.
3 months, 5 months shortfall. 5 months lacking. He was suffering from mental disease.
Suffering. That is not an issue. Thing is
But
that
if he is suffering from a mental
medical sufferance, that's it. Medical sufferance. Thing is that he has not regularly medicalized or hospitalized. Sometimes
he'll be. Sometimes. He will have some lucid intervals, is true. The mad is not always permanently mad.
Right.
Sometimes lunacy intervals are there.
Right. That is there. So when he was asked for his so-called, before initiating of the DA, there he never replied.
No, he's not well at all.
The thing is that was duly communicated to him.
He is more a patient. A patient is in English law called doli in capax. That's a famous judgment by Lord Macnaghten. We were taught a Macnaghten rule in Kenny's criminal jurisprudence, criminal outlines of criminal law. The mental insanity, medical insanity. That's a beautiful judgment it is. Okay, that then law is developed by European Human Rights Commission. For taking cue from Lord Macnaghten, they have gone further now. See, we all have some amount of madness. Yeah, this is what Coelho says that in his famous Alchemist. We all have some measure of madness. Only difference is many are capable of controlling it, and others are not.
And madness is also required in a way to enjoy the life. That is also required in a way.
See, he also suffered the injury in course of and arising out of employment.
Out of
employment.
There is some material available to
the condition of the employee as the senior section engineer himself had seen Mr. Adhikari, the delinquent, found lying with a head injury in front of the stores and himself had shifted the patient to the railway hospital in ambulance. So while he was in
the store itself.
But while discharging the duty,
No, discharging means
suppose he's in drunken stage now.
That's not the case.
Is in premises.
In the premises.
Within the premises. That is
Storehouse. It is a storehouse. Generally, in storehouse, nobody keeps it very clean. Some oil spilling happens. Some slippery things fall down. And while discharging our duties, we fall down. That is a case. No, there you have to be little considerate.
That's
so such people.
the order improving the position on put is that order passed by the land tribunal, where the land tribunal has felt it proper to reject the application of the petitioner on the ground that she has prepared the application with certain delay without any sufficient explanation. That is what
She is not in the court.
She is after the.
She is not in the court hall. She is a widow.
She is a widow.
She has lost her husband.
Right.
Kindly imagine, you should always think what I would have done had I been in her shoes.
In that event, may I suggest Lordship may remand back to the concerned tribunal?
Well, again, how many years? It will go on, widow will die.
No, but unless until this part is duly educated.
No, on the basis of material, we'll do that. It's a special case. See, 19 years, 7 months here.
Yes, around.
There is no complaint whatsoever against him. He was admitted to hospital on 8/7/1998. And throughout he went there. 2 persons carried him to the quarters because he was not in a position to maintain himself. That is the reason 2 persons were deputed to watch his confinement. This is where the government has to be little magnanimous. Government should not be like a butcher. It should be more like a surgeon.
Yes, that's true. But somehow is.
No, it's there. It's what your brother pointed out. He fell down in the storehouse. It's there during the course of and out of employment, during the course of employment. It's like that kind.
Employer has a
Section 3 of the Employees Compensation Act
Workman's
1923.
You have a different obligation otherwise.
This is the otherwise obligation.
If it is established during course of employment, then it is to be considered. That is the 30% law.
That no, but for that now,
That's it.
we have to set aside the removal order.
Removal order again.
Removal order has to be set aside. Then he will be deemed to be in employment. Then you will consider his application for VRS with whatever benefits he will get. This is such a case. It is not, you cannot act that way. We are all, see, government is a model employer. The 2013 Supreme Court.
Vendranath Hazare.
Correct. Hazarika meant. Hazarika versus Bhupendranath Hazarika versus State of Assam. So model employer means that only. We'll come back. We'll come back.
I have undertaken to file, your Lordship wanted that we are Justice Hon'Ble Justice.
Yeah, we got that judgment.
These are the 2 judgments I have got. Up to
Gawai Saab's judgment.
Yes, ma'am.
Yes.
Both their judgments are of Hon'Ble Justice.
Was not fair because I am told by my other side, appellant, sought for time and it has been adjourned to next week. May I pray, my lord, only 7 or 8, whatever content.
It is already signed. We have signed the paper. When it comes to mention.
Because 24 years were directed to regularize the not allowed.
But already we have
Yes,
sent the-
that is, I cannot.
Sir, I'm extremely sorry if you not permit me.
Yes, Mr. Minister. What is the point?
Item 22. The briefing council actually contacted me in the morning.
22.
Yes.
Now, which date it is put to?
22. Actually, I felt a little bit jealous. He said that I'm coming from London.
Yes.
Requested me to get a short adjournment.
That adjournment you want. Which date he wants? Next week?
First week.
First week to next week.
Next week, it will hardly 2 days. Hardly 2 days. Next week.
Next week?
Yeah.
2 days? No, it is
you
1 day. If you
A week after. A week after Lakshmi.
if you do not agree with that also, there is no date.
Right. Anyways, next week, let it come next week. In the event it does not reach it, we can post it to someone. Well, not.
We commence in 6th करना हम. We commence in 6th.
We commence in 6th.
We commence in 6th.
Yes.
Yes, 6th. After 2 weeks. 2 weeks. Okay.
Item 11, OGC 146.
No, we were in the middle of hearing of this first.
Here, let's may please. Let's may kindly turn page 67 of the brief.
67.
There, Lord's was asking the question: what is the length of service he had? That is the document.
Shortfall is how much?
Shortfall, that is
18 years, 2 months, 7 days.
7 days. So around, say 22 months shortfall.
No, my lord.
That is what the document they filed.
No, my lord. And the calculation might be wrong. Page annexer 15, page 48. I have calculated the calculation sheet given. Service begins from 25,979 and it is ended 19,2000.
25,9?
Yes, my lord. 25,979. So it is ended 19,2000.
2000. He remained absent since March 98.
Absent.
He remained
But
absent.
qualifying service, absent. So, my lord, absent period, I have calculated all. 2 years, 1 month, 22 days. So, from the till the date of removal. So, I was hospitalized in 9/7/98. So, removed on 1/9/2000. So, it is 2 years, 1 month, 22 days. So, that is 18 months their calculation.
That is what they document.
So,
of the department only, they separate document.
It is because
it is what
Yes,
is annex.
Till termination takes place, he is deemed to be an employee.
Undoubtedly.
So, from the date of entry into service to the date of termination, what is the figure?
That is what's stated in this page 67. The date of entry is 25th September 1979.
Correct.
And date of removal is 19th of March 1998. That is what the calculation given by the department.
Yes.
19th of March.
19th of March 1998.
No, my lord.
And accordingly, it comes around.
Please. A delinquent is removed from railway service with effect from 19/2000. Page 48.
Page 48.
48, my lord.
Where is the order of removal?
Page 48. Annexure 15. Service particulars given below. Begins.
Yes, brother. What we suggest is, we are giving an option to you. We will set aside order of the CAT and we direct you to reconsider the claim of that person, that lady now.
We do it.
For what is that? VRS?
No. He was not also eligible for VRS because 30 years of
shortage of time.
That was that is the case.
Now what benefit
she is asking for the some pensional benefits which is not
20 years is the
20 years.
No, it is the removal, not dismissal.
I'm clarifying. So he died in the year 5/7/2003. Removed 2000, died 2003. So as per the service book, his normal retirement would be 6/1/15. But before that, he died 6/1/15. 2015.
Now,
So he died.
now you want to have pensionary benefits.
All pension.
For pension, the qualifying period is 20 years.
10 years.
10 years.
Minimum 10 years. So for getting the rule 67 of the railway pension rule.
The minimum pension will be on that is qualifying period.
Qualifying period, my lord.
Is 10 years.
10 years.
Is it true, brother? Which rule?
Rule 67.
No, if it is 20 years.
Yes.
If
Well, qualifying rule 67. 67 and rule 55. Invalid pension 55. Rule 67.
Swami, sir.
Swami. Railway pension.
Very brother, sir. Swami is very good actually.
Rule 67.
Voluntary retirement. It's a case of voluntary retirement.
No, my lord, they are processing the file to give me voluntary retirement because shortfall, due to shortfall, it could not be materialized. Thereafter, they removed me.
Now, if VRS is given, you will be entitled to pension and other things.
Pension.
As if you have retired on that day.
Fine. So, my husband died 2003. Removal 2000. So, after 2 years, he died. So, normal retirement is 2015. So, prior to that, he died.
You reconsider the issue.
Yes.
What issue?
So, but GPF and family pension is considered. That I think my friend was
No, that question arises.
Family pension.
No. 1 second, sir, you do not. Question of family pension arises only if he has drawn the pension at least for 1 day.
1 day.
Not otherwise.
On superannuation.
Now pension is not given because voluntary retirement is not accepted.
Because of
all these. Now, see, he is a person suffering from psychological problems. Mental illness. Is it not? So, a person of mental illness cannot be removed unless his guardian is heard in the matter. He is like a child. He is a doli incapax in a way. Like a child, he will not be able to take a rational decision because he will not know its impact on his interests. Therefore, the principles of natural justice are violated. You should have sent a letter telling his wife, see, your husband appears to be not that good. Read this letter to yourself. This letter is meant for your eyes only. We feel like this. Therefore, now we want to terminate his services. We can't retain the deadwood with us. Trains will not run. Therefore, we want to remove him. What you want to say? Number one. Second option was, he is our servant. We will send him to the best of the psychiatric institution. He will have psychiatric treatment. He becomes normal. Then we'll issue him notice. You have become normal now. We want to remove you. What you want to say? That would have been the second.
Those endeavors were made somehow
because he is not the East India Company.
That's
we don't. You have become invalid, therefore you should go. That is not the object of welfare state.
But as it found on the record, let's say page 64 is also there. That is during 87. 87. One record is there, page 64, saying that having been held guilty in the charge for indisciplined conduct and neglect of duty, as detailed in CS number so dated 21st/9/87, he is, matlab the husband of the petitioner, he is punished with stoppage of his next annual increment for a period of 6 months. This is what similar other things are there. It is a conduct. And somewhere the authority said, sir, he is not cooperating. He's simply coming and going away. That is, there are some.
No. After that, he has joined in. 62, page 62.
You did not remove him.
Party joined on duty on 10/1/97. Then where is the question? As to Palasi.
This is how
Reversion.
not only that during 98. It is a case that he used to do in the spirit. It's common neglect of duty.
Because of the disease.
But the injury, as Lord pointed out,
that happened afterwards.
Afterwards. That is why I want to just try to find. It is a contact with the person concerned. He simply comes to the office, sitting quiet. If some officer is asking for something, he used to misbehave. That is the record. I'm not telling anything. It is the record. It is a record. But
that the management should have appreciated keeping in view his ailment.
Lordship,
which happened only inside the premises.
Grateful, Lordship. But by the time 87, 88, that was not the story. That is what I want to point out. That is what I want to point out. During 98, I can understand. But this is a conduct with the person concerned. And officers became frustrated. They have also wrote to the sir, we are unable to proceed the matter, sir. He is misbehaving us whenever asking anything you in duty. That is the record. I'm not telling anything beyond that. I'm only the record only. Lordship, permission, I can place it also.
See, unilaterally, you went on giving him punishment and whatever. He didn't bother for it because he does not understand.
But by that, it was quite normal, Lordship. If like that says.
No. You're
only 98, Lordship, he fell down. During 98.
No. Scalp injury. And age 22.
Only after that.
Page 22.
Right to the accident, you find if.
No, Lordship, that was what I'm submitting, Lordship. Page 67, I was reading out. There, Lordship, it is a case of 87. During 87. I am reading page 64. There, Lordship, kindly see, it is a case of during 1987. When this occasion was not there, as that mental illness, all these things. That's so somewhere, somehow, he was of such conduct.
That annual increment was
stopped. Yes, because of the conduct. So, there are records that he was not so serious on his duty. Later, because of attitude or something like that, he fell down, sustained some injuries, and thereafter all these things came. That is somehow based on records. But this is also a part of record that he was of such conduct. For that reason only. It is their record only. I am not submitting anything out of record.
Page 22 also, there is serious scalp injury.
No, that's there.
Page 24.
That is there. Now the whole thing is Lordship. So Lordship only Lordship consider. Because a person is simply sitting quiet and misbehaving the authorities if he is asked to do
There's
something.
one provision in CPC. When a person is of unsound mind, order 75.
The thing is that nothing shall be done till he recovers. That is the fundamental. That is the thing. But here is a case, allegedly during 1998, he fell down, sustained scalp injury. Then these things can be imagined. But Lordship kindly see the story previously. That is during 87, 88, those things.
That's all misconduct.
Misconduct.
But it is not on that ground you have removed him.
No, as on date, the cause of action arose, that was not for that 87. It is only after 98. That is there. That I can't dispute.
No, what we were just thinking. Any decision which said where employee is not
sound mind,
man of sound mind, how he should be treated if there is delinquency, etc. In criminal cases also.
No proceedings shall continue till he recovers.
We had Integrity Act earlier.
Insanity,
Lunacy,
all these things.
Lunacy Act.
Yes,
my lord, CPC principle will apply. Here, the insanity. What is that? Lunacy. Because your lordship says that he should be defended by one guardian. That
there is such a provision, no? CPC. Order 35 or 36.
That I have to check off.
32. Order 32. Thank you. That is where
indigent, unsound mind.
20 for defendant is of unsound mind. How he will be treated? That way, that principle will be absolute.
Truth by and against 32 unsound mind.
Yes, Rule 15. There is Mental Health Act also. Mental Health Act also. Any provision is there? So pension is available under Rule 69.
69. And the invalid pension also, my lord, Rule 55.
No, that we do not know. No? You had applied for VRS.
PRS.
You had applied for VRS on which date?
He has never.
98, my lord. 8 file was processed on 9/7/98, page 31. Under the above circumstance, it is very difficult to maintain the work smoothly. So you are requested to take necessary action for his compulsory retirement or voluntary retirement on administrative interest. Page 31.
By one officer to another officer. It is not by the
Communication. It is a communication.
Interdepartmental
communication.
That page 31. What my
They said you make you compulsorily retire.
Either this or that, because he was
This
not by
VRS not possible to work.
Not possible.
Generally, the problem, people having psychiatric problems
Used to behave in this way.
difficult to
Work with them. Environment will be political like that. For that reason, the officer felt it proper to take some good action. That is 31, page 31 says in that way only. It is a subjective nature showing the misconduct or license by the party concerned.
Whether about a psychiatric problem also they mention.
That part, Lordship. May I read a small para? May I read, Lordship? Page 31. I am reading Lordship. It is legal with reference to the letter cited above. It is understood that after thorough examination of service sheet of Sri Ajay Kumar Adhikari, husband of the petitioner, Store Khalasi, so-and-so Khurda, has not attained 20 years qualifying service for which his voluntary retirement not be accepted by administration.
Not be accepted means he had applied for VRS.
Not that part is
no, otherwise he would not.
It can be interpreted that way, but not. Cannot be. But as a matter of fact, Sri A.K. Adhikari does not want to continue in service and he is reluctant to work. Full stop. He is coming to duty and going away without doing any job. Full stop. He does not carry out the order of the superiors and not maintain discipline and principle. Full stop. Moreover, his behavior is too rough. As result, many unpleasant occurrences took place, and RPF taken him under their custody. RPF,
Railway Protection Force.
Yes,
that means police to keep
police
him
should take because of the all this.
Yeah.
Further, next parallel. Further, you are advised. Here means the authority. You are advised to send him Railway Hospital Khurda for mental treatment.
Correct.
Comma. Video letter number so-and-so dated 14th May 1998 and arrangement made accordingly. But party refused to take shelter in this effect nor attended railway medical. His motivation is only to sit tight and enjoy full month salary. Full stop. If I advise him to do any work, he revolted against me and threatened me. Full stop. Next para. Under the above circumstances, it is very difficult to maintain the work smoothly with him. So you are requested to take necessary action for his compulsory retirement or voluntary retirement on administrative interest. This is what the letter.
By senior section manager.
Engineer, SC Railway, Khurda. So this is all things. It was addressed to senior DME Khurda.
What notice was sent to him before removing him from service?
Before removing service. Also.
Any inquiry was held?
Yes, inquiry held. That we have filed our counter in this case, to which they have never replied.
No, where are the documents to show that inquiry was held? Then punishment order is passed, removing him from service.
So far, those relevant documents plus you see, then in our counter we have categorically mentioned those things.
No,
that piece of documents are not at us.
When the inquiry was held, how inquiry was held, who held the inquiry, who participated?
None has participated. Notice was duly served through special through post and by attaching at the wall. That part is over. Neither in the inquiry nor in the proceeding.
That inquiry will not be proper in accordance with law. Reason being, because your own certificate shows that you are suffering from schizophrenia. Yes.
It's a case of
schizophrenia. It's there. Medical certificate.
Schizophrenia is a very degenerative
It's a higher degree in every. Sometimes loss of memory.
I suspected it when you read it. He threatens, etc. Because they operate it's more like bipolar. Extremely violent, or they become extremely violent. It's a bipolar manic disorder.
Sometimes cool, sometimes hot.
That way.
So this is how the story looks. Now, if she is asking for some financial assistance, Lordship may say that we will consider entirely on these aspects.
Keeping all these things open.
And without recording my concession, Lordship may kindly, as the Lordship desires. But this is what the past conduct also. Is that light?
Schizophrenia. Certificate
clear that is there. Schizophrenia is there. It's going to that. And as my friends says that the widow is getting some
allowance. They have given certain allowance during pendency of this writ petition.
What allowance?
My lord.
Monthly allowance.
My lord, by confirming the order of removal, only compassionate allowance.
How much monthly?
Now she's getting, my lord, 11,000.
Every month?
Every month, 11,000. Compassionate allowance.
Monthly allowance?
Monthly allowance.
Then she should be happy with that.
Because even he had the pension been there, it would have been 50% for the...
No, not 50%. Because 50% is possible only if he puts in full service.
Yes. And
so
it's not completely. It is pro rata.
Because Rule 69 says
50% of pro rata.
Pro rata.
If the...
In case of a railway servant resigning in accordance with the provisions that is there, right, before completing qualifying service of 30 years, but after completing the qualifying service of 10 years, the amount of pension shall be proportionate to the amount of pension admissible under clause A, and in no case the amount of pension shall be less than rupees 375 per mention. This is amended.
It is amended.
So now she is getting that 11,000 rupees.
My lord,
not working. Why government should spend money on your client?
No, my lord. So the amount, so it will be. I was calculating variation would be 1,000 something if the service would be regularized till the date of removal. So it is, my lord, from.
Now your version that because of the fall schizophrenia is set in may not be true. It does not happen just by a fall. I'm not very sure that it happens because on Modi's medical legal jurisprudence, in one edition it has stated during my student days. He referred to Mann on abnormal psychology, and he opines generally the schizophrenia does not happen just by mere fall or stroke, something like that. No. It is a mental degeneration, cerebral degeneration that happens in the long run. Yes. That way it is. Take out some Google, go to schizophrenia, genesis, evolution, and treatment. Good. There are good books on that, in fact.
Mr. Mahathi, if you have received 11,000.
No, my lord. The allowance, my lord, allowance.
Filing the case.
No, my lord. My lord. During pendency of this writ petition,
it has happened.
Well, personally approached the general manager. So on consideration, the prayer, so they have given the compulsory allowance from 17.5.
We were under impression she had been left high and dry.
No, my lord. 16. It is effective from 17.5/2016. So my date of removal, 2000.
Even before removal, she is being 2000 it is.
Removal. So
That
they
is subsequent to
effective from my allowance is effective from 2016.
schizophrenia.
17/5/2016.
No, then will not interfere.
No,
just there is something government
Not
is
that
doing.
probably they have not.
If they had not given, we would have said.
So because
already you have spent a lot of time.
no, my 17/5/2016 I am getting. So my removal is 2000. So I pray the compassionate allowance be given from 2000 because it would be
Why we should pay for maintaining your husband? Your husband is a man of disease, and railway is not the cause of disease. Unless there is nexus between your work and your disease, it will not be out of employment in the course of employment. There should be nexus. That is how courts have held under Section 3 and 4 of the Employees Compensation Act 1923, which was Workmen's Compensation Act 1923. The injury should arise out of and in the course of employment. How railway, its horn, its sound, its heat, is it responsible for triggering the disease? Where is the material? How can we assume on that? Schizophrenia, essential treatments. Causes of schizophrenia. Put in that. Causes of schizophrenia. No, there is nothing. He fell down means why he fell down, we don't know. Yeah, put that.
This is highly genetic.
Generally genetic.
Yes, yeah.
Hereditary
Study
disease.
suggesting up to 81% genetic.
See the propensity. If parents, grandparents, if the propensity of one becoming struck with that disease is more 80%. 80%. The exact causes of schizophrenia are unknown. Research suggests a combination of physical, genetic, psychological, and environmental factors can make a person more likely to develop the condition. Schizophrenia tends to run in families, but no single gene is thought to be responsible. It's more likely that different combinations.
And he is having a behavioral disorder right from the beginning in 87.
Behavioral disorder is there. Means the disease started getting expression in 87. That is the reason he said, he is threatening us. If we tell him work, he threatens us. Therefore, compulsory retire him or remove him from the service. We sympathize with your client is one thing. But why we should pay for your disease? Why railway passengers should pay for your disease unless they are responsible for that? As your brother rightly pointed out, some statistical data is there. They say this is generally hereditary. It runs in the gene runs in the family.
Despite that, if they have considered this.
And they have given that money also.
My lord, I pray because the general manager is of the sympathetic view. So he has allowed the allowance from 2016.
Earlier date
16. So my lord, my application, because
one thing we'll give you.
My lord.
Now, we only proposal. We will pass the order on me. Now, during the pendency of the petition, we are told at the bar that the monthly allowance of so much is granted to the widow of the deceased employee, and it is given with effect from such and such date. Employee says it ought to have been given with anterior dates. In that connection, it is open to the petitioner to make a representation, and if that is made, a decision shall be taken by the railway department in accordance with law.
Grateful note.
Are you agreeable with that?
That will help me. This way that.
We will say that we say, because it should not come on both of you. We said like this.
Right. That will save us.
And you agreed to that one.
Right.
All right.
Substantial justice.
Petitioner, being the widow of a deceased employee, he is knocking at the doors of High Court for assailing Cuttack's Central Administrative Tribunal's order dated
29 September
29/9/2014, whereby her OA number 260/00707
704, sir.
704 of 2014 has been negatived. First up, in the said OA, she had laid a challenge to the order dated 10/9/2000, whereby her husband was removed from service on the ground of long unauthorized absence between 9/7/1998 and 1/9/2000. Correct? 2000. Next paragraph. After service of notice, the OPs having entered appearance through the learned senior panel counsel resists the petition, making submission in justification of the impugned order and the reasons on which it has been structured. First up, we heard the matter for long. First up, we do not find much merit warranting our interference. In as much as the petitioner is being paid a monthly compensatory allowance of rupees
11,000
with the effect from
17/5/2016.
17/5/2016. The removal having happened with effect from 1/9/2000. Correct?
Correct.
1/9/2000. First up. A perusal of the records would demonstrate that the petitioner's husband had a mental ailment, into brackets, schizophrenia of some order, some degrees, into bracket complete, and that his work at the place was not satisfactory. First of all, go to page 31. 30 or 31, you read, no?
Let's see. That one. Page 31, let's see. Excel 6 series, that is.
The senior section engineer,
SC Railway.
SC Railway Khurda.
The road.
What?
Khurda Road.
Khurda Road.
Khurda Road.
Okay. Wide letter dated 9/7/1998, a copy whereof avails at Annexure 6 series, had told to whom he wrote?
Senior DME Khurda.
Told the senior Divisional manager.
Divisional mechanical engineer. Divisional mechanical engineer.
Yes.
Divisional mechanical engineer Khurda about unhappy work culture of petitioner's husband and his violent behavior that came in the way of extracting work from him. First off, he had suggested for his compulsory retirement or for accepting voluntary retirement. First off. At a bit before, petitioner's husband was punished by withholding increment for a period of 6 months for being amiss. First off. Be that as it be. Next paragraph. Regard being had to totality of the circumstances, more particularly the deceased employee being a victim of schizophrenia, and also petitioner being granted compensatory monetary compensation, compassionate allowance.
Compassionate allowance.
Wide letter dated 17/5/2016 issued by the Assistant Personnel Officer on behalf of Senior Divisional Personnel Officer, Khurda Road, we suggested and the bar graciously agreed that the petitioner may make an appropriate representation to the jurisdictional authorities seeking a grant of compassionate allowance with a retrospective effect from the date of removal, that is 1/9/2000, or at least the death of the employee on
5/10/2003.
5/10/2003, as the case may be, in accordance with law. And that the decision has to be taken on the contemplated representation within an outer limit of 3 months. 3 months. First up. We further told that all contentions in this regard need to be kept open for consideration by the jurisdictional authority. First up. Next, for example. In the above circumstances and with the above observations, this petition is disposed of. Costs having been made easy. Okay.
I pray gratuity
gratuity because of the imposition of penalty removal. So they are telling that it is being forfeited.
Yes.
So gratuity I will get some certain 80,000 something.
It is also open to the petitioner
because of the removal order.
to seek grant of gratuity payable to the deceased employee in accordance with law. Okay. Okay.
Let's say I have filed my APRS memo, that may be taken.
Yes. But we appreciate your fairness in telling the court that she has been sanctioned the allowance, etc. That's good.
Before leaving your lordship, I being accompanied with widow approached the general
authority and
general manager being gracious. So only thing is that they are telling that we stick to the order of removal. So allowance. But unless the removal order is recalled either by the court of law or by the appellate authority, we cannot grant you the further benefit.
No, further benefit is not interfere.
Further benefit in terms of my lord, the rehabilitation assistance, because prior to normal date of retirement, he died.
Next.
Item 21, WPC 159254 is against 19.
2014. Yes.
India filed state application challenging the order of tribunal.
Union of India has come.
Challenging the order of tribunal. The case is that 243 seats, 243 seats in respect of postman and mail guard were notified. The advertisement.
What is this matter about? In just 2 lines, 3 lines.
Just my lord, he belongs to OBC category. Only horizon because of DOPT circular.
Horizontal reservation.
Horizontal reservation has been given to ex-servicemen and physically handicapped. So those 2 posts has already been filled up by the ex-servicemen candidates. So he has secured highest marks than those candidates, but to OBC category, to OBC from ex-servicemen category, we have filled up those posts, and thereafter that is why he approached the tribunal. That since he secured more marks than those 2 candidates, so tribunal has directed to give an appointment. That is the crux of the case. Our case that 200 out of 243 seats, as per the DOPT circular, DOPT memorandum, we have given first ex-servicemen and physically handicapped. 25 seats were reserved for the ex-servicemen and physically handicapped.
25% to
25 seats, 25.
Oh, vacancies.
Vacancies. 25 for the ex-servicemen.
Totally, how many vacancies were notified? What is the advertisement dated?
Advertisement, my lord. 22nd August 2014 at page 36.
2014,
my.
How many vacancies?
Vacancies, my lord, 230.
241.
235 plus 8, 243.
What are those posts?
Those posts are my lord. Postman and mail guard.
Postman.
Postman 235 and mail guard 8.
Mail guard, MAIL.
Mail
guard. Yes.
Which includes also 25 vacancies for ex-servicemen and 7 vacancies of PH category.
25 for X. And 8?
240, 235.
Totally 235.
230.
Plus 8.
Plus
243.
243. Of them, 25 is earmarked for ex-servicemen.
And 7 for PH category.
They come in what category? This is a horizontal.
Horizontal.
Okay.
We have given appointment under horizontal because of 2 posts kept vacant for OBC category has been filled up from the ex-serviceman OBC category on the basis of horizontal reservation method.
OBC?
So, 2 posts for OBC category. On reserve 142. Your Lordship, kindly have a glance to page 43 reservation. The vacancy position is there, ma'am. 144 unreserved and scheduled caste 44, scheduled tribe 51, OBC 2.
Scheduled caste?
44.
Scheduled tribe?
51.
OBC 2.
OBC 2. That is total 241.
Should be 243, na? The 2 is OBC.
No, man. Here what happened, subsequently that has been earlier, what happened, earlier the advertisement was published for 241, subsequently it was modified to 235 plus 8, 243.
43.
So how many male guards?
8 male guards, na?
235 postmen, 8 male guards.
243, why it is mentioning 241?
That has been, I think,
this is from Postal Department.
Postal Department.
Now, what is their grievance?
Here grievance, Your Lordship, kindly have a glance to page 59. The order will reflect everything.
59.
Page 59 of the rate application. The Odisha Circle, last line, the Odisha Circle has issued notification for filling up 241 vacancies postman and 8 vacancies.
They are saying 241.
241, subsequently that has been, I think, modified to 243. Your Lordship, kindly see next 243, 142 was subsequently modified. 241 earlier, that has been modified to 243. That has been postman 235, male guard 8, total 243. Their scheduled caste, scheduled tribe OBC 44, 53, 2, and on reserve 144. And 25 vacancies of ex-servicemen and 7 vacancies of PWPS category announced to be adjusted under horizontal reservation as under mentioned. So out of 144, 21 has been given ex-servicemen.
This was challenged before the CAT.
CAT, man.
What CAT says no?
CAT, man. CAT has directed to give appointment.
How? On what basis?
On the basis of column number 11, number 1 of the advertisement only.
What it says?
That, Your Lordship.
Column number 1.
11.1. Page 84 of the order, Your Lordship, kindly have a glance to paragraph. In this connection, we have gone through the paragraph number 11, number 1 of the vacancy notification dated 22nd August 2014. In the
each of the
total number of applicants as per the total number of vacancies in each category OC, SC, ST, OBC, etc. shall be declared qualified in descending order of merit based on the marks secured by them in the a plain reading of the above quoted provision on the basis of that merit.
Based on the marks secured by them in the aptitude test, irrespective of whether all or some of them are ex-servicemen or PH candidates. At the case, therefore, the applicant must put verification secured higher marks than the private respondent numbers 4 and 5. They have secured more marks than these two. Tribunal says it should be prepared from high to low. Correct, it is.
Merit.
But your lordship, kindly see the DOPT circular, page 98, which says horizontal reservation should be given to the ex-serviceman and physically handicapped.
Correct.
After the shortfall of those seats, my lord, thereafter we will
How many vacancies are there now?
all the seats were filled up.
No vacancies are available. Where have you stated? No vacancies are available in your petition.
243 seats were given. That also we have we have given the table also.
No, whether now these two vacancies are available or not, they are very more meritorious. You have committed a mistake. Tribunal has given a reason there.
Now, your lordship, kindly see the page 46 onwards. These were the result sheets given to the general candidates, SC/ST candidates, ST candidates, as well as ex-servicemen. Only the point is, your lordship, kindly have a glance to the DOPT circular. DOPT circular clearly says that page 98, column number 19, horizontal of reservation for persons with disabilities. Reservation
Page
for
19.
Page 98. Column number 19, horizontality of reservation for persons with disabilities. Reservation for backward classes of citizens, scheduled caste, scheduled tribe, and OBC is called vertical reservation, and the reservation for categories such as persons with disabilities and ex-servicemen is called horizontal reservation. Horizontal reservation cuts across vertical reservation in what is called interlocking reservation.
Whatever is given to SC, ST, OBC,
they are
is vertical. Other than that, reservation is horizontal.
Horizontal.
Simple. As simple as.
So we have given first horizontal reservation to ex-servicemen and physical handicapped. So because of that, my lord, two ex-servicemen belongs to OBC category, so they got appointment under the horizontal reservation basis, my lord. That is why two posts were filled up by two posts of the OBC category has been filled up from the ex-serviceman category.
May I clarify this?
That also ex-serviceman table also I have given in page 51. Those 25 persons.
They belong to which category?
OBC category.
If it is OBC, then it has to be vertical only. Even going by your own option, come to page 91.
Page 98.
98.
But your lordship, kindly have a reservation for backward classes, SC, ST, and OBC is called vertical reservation. Correct. And the reservation for categories as person with disability.
Disability.
Then your lordship, kindly see page 51.
51.
Here, page 51. The list of candidates of ex-servicemen. First is Anil Kumar. He belongs to general and as per the horizontal unreserved category. Then general unreserved category. Then general unreserved category. Then
that does not make sense. Question is, kindly come to the reasoning of the judge. First, we felt that you are right. Kindly see the reasoning of the CAT. CAT judges have got accumulated wisdom in service matters. They are more, they fare well than us actually. Let me at least see that you have shown that reservation policy you have given, they have given illustration, etc.
Yes.
That you have seen now. Go to last but one paragraph of the impugned order. Go to impugned order of the tribunal.
The one that you are reading, in fact, from 10 onwards.
Yes. A plain reading of the above quoted provisions in the advertisement makes it amply clear that the merit list has to be prepared based on the marks secured by the candidates belong to each of the categories. Viewed from this angle, the candidates in respect of OBC category should have been declared qualified in descending order of merit based on the marks secured by them in the aptitude test, irrespective of whether all or some of them are ex-servicemen or PH candidates, as the case may be. Therefore, the applicant indisputably having secured higher marks than the private respondent 4 and 5, his name ought to have been found placed in the merit list above the names of the private respondents number 4 and 5. It is a matter of fact that the official respondents have not prepared the merit list in conformity with the paragraph number 11.1 of the notification dated so. Apart from making a submission that as per the guidelines instruction of the department, the vacancies for ex-servicemen and PH categories are to be filled up first by making horizontal adjustment coming across the other categories. Respondents have not produced any document evidence in that behalf. Be that as it may, it goes without saying that there is no reservation for ex-servicemen over and above the vacancies reserved for unreserved SC, ST, OBC as the case may be. The contention of the respondents in this regard are not as per the provisions of the notification dated so and so. Manner of selection of ex-servicemen and PH category has not been specified in the notification dated so and so, and no rule or policy guidelines of government has been furnished by the respondents in support of these contentions. Since we are unable to accept the process of selection of ex-servicemen as stated by the respondents, by which OBC candidates such and such with less merit than the applicant have been selected under ex-servicemen in contravention to the para number 11.1 of the notification dated so and so. In this
if we agree with your contention, less meritorious will march over.
Because of the horizontal reservation, that is your lordship, those candidates, those candidates belongs to ex-service unreserved category number 1 also got less marks than the persons who has secured more marks in the unreserved category. Because of the horizontal, first we have filled up all the horizontal, all the ex-servicemen post and physically as per my instruction. They have finished the those posts were filled.
10, 11 appear to be. Pardon, my lord. This case, this issue has been well explained by the Honorable Apex Court in case of Rajesh Kumar Dharia versus State of versus Rajasthan Public Service Commission. I am passing down. It's very lucidly explained there, my lord, how to calculate, my lord. And in this case, my lord, as per the rule, that is, my lord, I have annexed that rule, my lord, in my counter. That is ex-serviceman re-employment in Central Civil Services and Post Amendment Rule 2012. Their, my lord, percentage of reservation should be 12% only. So out of 2 posts, nothing can be, my lord, reserved. There are unreserved posts and other posts in which there is a number of posts, my lord. From their posts that can be go for the ex-serviceman if there is a shortage in the participation of the ex-service candidate in the merit. Only, my lord, there is a shortage and there is a less participation, nobody can, my lord, surpass the merit, my lord. And that is exactly, my lord, what has been calculated by the Honorable Apex Court. Most very relevant is para 6, my lord. It's very relevant, very relevant. We may also refer.
Yes, my lord. And in this case has been cited in number of cases, recent cases also, my lord. It says we may also refer to 2 related aspects before considering the facts of this case. The first is about the description of the horizontal reservation. For example, if there are 200 vacancies and 15% is the vertical reservation for SC and 30% is the horizontal reservation for women, the proper description of the number of posts reserved for SC should be for SC 30 posts of the which 9 posts are for the women. We find that many of the time this is wrongly described thus. For SC 21 posts for men and 9 posts for women.
So on gender-based reservation is not there.
No. Only when there is a less participation, then the horizontal reservation can be involved. Otherwise, no. If, my lord, in the list, merit list, if the participation is there, my lord, number of percent, so then no need to change any or going further.
When participation is less than what is called for, then all these questions.
Here, my lord, the post is very less, 2 number of posts. So nothing can be, my lord, reserved for the horizontal category because the posts are less. So what they have done, my lord, they did 100% reservation for a single horizontal category. They did my lord 100% reservation.
Effect of what they have done amounts to 100% reservation.
Yes, my lord. The 2 posts has been given to the less meritorious candidates. That was the case before the term. One OBC category of ex-servicemen from ex-servicemen category OBC also got an appointment in unreserved category. That is also the your lordship kindly see.
But the recommendation of the Apex Court.
Then you'll also kindly see
It completely answer, it dispels your version.
but Lordship kindly see the rule they have provided in counter affidavit, paragraph number.
This is the, which judgment is it? 2007. This is how we have understood horizontal reservation. Even according to your literature also. Vertical reservation, horizontal reservation, you have said everything correct. But when you come to its operationalization, you have erred.
But your Lordship kindly see the rule. They have relied on a rule in counter affidavit, page 13 of the counter affidavit. Lordship kindly see. If sub-rule 2, the following sub-rules shall be substituted, namely the scheduled caste, the scheduled tribe, and the other backward class candidates selected against the vacancies reserved for ex-servicemen shall be adjusted against vacancies reserved for scheduled caste, scheduled tribe, and other backward classes respectively. Provided that if a scheduled caste or the scheduled tribe or the other backward class ex-serviceman is selected against the vacancy reserved for ex-serviceman and vacancy reserved for the scheduled caste or the scheduled tribe or other backward classes, as the case may be,
not available to adjust.
Is not able to adjust such ex-serviceman, it shall be adjusted in future against the next available vacancy reserved for the scheduled caste or the scheduled tribes or other backward classes, as the case may be.
No, that does not alter the position.
Even if
it alters the position, legal position, which the apex court has said in that 2007 judgment. This is Rajesh Kumar Daria.
That Rajesh Kumar Daria, let me go through, because after 2007, maybe 2-3 judgments are there on this. Let me verify. Because recently, my Lord, Honorable Apex Court in the Honorable Justice.
They took time, my Lord, 3 occasions on the judgments, my Lord. They have to occupy a judgment.
Can we take on Monday, my Lord? Monday. I'm not praying for much time, only for Monday.
How much time we are spending like this non-productive times? This judgment appears to be very sensible, actually. Having heard from length, having heard in length, matter is reluctantly adjourned by 2 weeks. Where we do not agree. This appears to be the correct position now. Daria, I think, is there latest decision which reiterates Daria?
Yes, last year decision is reiterated that Daria case.
Which decision?
I will give that, my Lord. I will give that.
Bring that judgment.
Yes.
Yes.
My Lord, kindly give a specific date, my Lord. After 2 weeks, yes, give a specific date. Oblige.
There is 13. Put some other 16. Brother, we'll have it 16. Tell him 16. Yeah.
Item 23, WPC 40736 of 2021.
My Lord, myself, Joy Chandra Misra, contesting this case in person. My Lord, this is a case for alleged unauthorized absence for 22.5 days. And for that,
one thing, in this case, the allotted counsel is on his legs. May I pray for Passover or tomorrow?
Which place you have to come from, Mr. Mishra? You have to come from which place?
My Lord, I am coming from Bhubaneswar.
Bhubaneswar?
Yes, at present.
Just here only, na?
Yes.
We will have this matter on 31st?
Lordship.
On 31st.
I'll intimate the counsel.
On 31st. At the request of the counsel appearing for the respondent.
Lordship, opposite part.
Okay.
Item 26, WPC 28590 of 2025.
Wait, please. Paid for refund of 17.5 lakhs. 17.5 lakhs deposited towards the auction sale price. In 2018, I have deposited the amount. The particular property is embroiled in different of cases, man, and it is in civil suit also. So I may be
That was
relieved
not
from
good.
that burden.
That was not mentioned in your in your
In advertisement, they have not. Advertisement was made on 20. My lord, the date chat I am giving, my lord.
Today I have already served a copy of counter on my learned senior brother and filing in official lordship. I pray 1 week only. I will take instruction. My learned brother is saying that to deposit that amount, the bid amount, before the registry of this.
The cooperative society is in very bad condition, my lord. And my personal experience, I am telling, my lord, just one. Yesterday, 3 days back, I have deposited a check of HDFC Bank in my State Bank account, my lord. They took 3 days to clear that amount. So the position, my lord, they see the position. He may take time, my lord. Call it on 7th or 8th, my lord. But in the meantime, ask them to deposit the entire amount that I have deposited along with interest. In order to secure my position, my lord, from 2018, my lord,
I have no objection. Only I may clarify.
You deposit that money in some other bank in the registry of this court.
Yes, my lord. I see.
What happens in this case? Like he has to implicate the loaner or borrower as party in this case because series of litigation.
Let us say, brother, he has participated in the auction to buy the property, not litigation.
Authorizer made the auction, my lord. I have made the authorizer.
Because one letter was issued to also to the auction purchaser to clear the rest of the dues.
That we'll see. First,
I have no objection.
First you deposit that money, whatever money he has deposited, you transfer it to the register. The registry
for that purpose only I pray 1 week time.
For this purpose? For depositing?
My lord.
I will direct you now first. You deposit it.
My lord may pass the order to that effect. My lord may
then we will fix a date, whichever date you want, we will give you. The UP Cooperative Society?
Yes.
No. Urban Cooperative Bank.
That's Urban Cooperative Society.
It is bank.
Cooperative Society.
This is
bank. Urban Cooperative Bank. Directed.
OP1, 2 may be directed.
OP1.
OP1 and 2.
Only one we can direct.
Authorized officer may be directed.
OP1 and 2 are jointly directed to deposit a sum of rupees 17,500.
17 lakh.
17 lakh 50,000 remitted by the petitioner pursuant to auction of security property held on
my lord 20 that is
Annex 1
and held on 28 12 2018 28 12 2018
pursuant to sale notice at Annex
under Annex 1
immediately first non-compliance of this order.
Like pray 7 weeks, 7 days only. Deposit
7 days. 7 days. First, non-compliance of this interim order may result into the defense of the bank being struck off. That's the only way now to ensure our compliance of order. We have to put threat in every order. Otherwise, nobody will comply with it.
No, I will comply because
you deposit that money.
My lord,
7 days. Within 7 days.
Within 7 days. Call this matter on 22nd April.
Your lords. In the meantime, I have served a copy of counter on me.
No, you already I deposit. Let them deposit that money. Next.
20, yes.
Item 27,
Sentence you are doing. This order is based on the alleged precarious financial position of the OP Bank. Okay.
Say, if you also see the last order, order that 17 to February, my lord. The interim order passed to lordship, my lord. And then make a remind your lordship the case short back, my lord.
Yes.
This order was passed on 17/2/26, my lord. On the very next day, on 18, they sold my property by auction, and they are not intimating whom they have sold, how much they have got it, and in the meantime,
We'll ask them first.
I have paid
Brother, this order, Eric Soils.
on 18.
It's not putting the correct facts.
No, we are asking you. There is an order by us.
Yes.
Whether auction has taken place.
Yes.
Auction taken place.
No, this is not related to this. That's
Yes.
He's not putting for the correct facts. There were two properties.
Yes.
The whole contention on that day was there was an MOU between the borrower and the bank. Property was to be sold to third party, that the OP3 here, for a 2 crore 3 lakhs. But bank, instead of adhering to the MOU's terms, they sold the property to same person though, but a lesser amount. The margin was 18 lakhs deficit. So the contention was that bank played a fraud. So my statement also recorded in the order that I fairly accepted. There was a problem. MOUs we did not adhere. So let the auction be cancelled completely and we will hand over that money. That's why Lordship passed the order against the OP3, the purchaser, not to alienate the property. What he is mentioning now, the other properties in Cuttack, this is the Bhubaneswar property. That was never contended by him.
Case related to which property?
Yes.
The Bhubaneswar property, Schedule A.
Huh? Let's see that.
OP3,
Yes,
if the OP3 has already purchased the property, that's why this the interim order, how the bank can sell the same property to some other person?
No. Yes.
OP3 purchased for a shorter, lesser amount. That's what is contention. In the MOU that was recorded between the parties to sell the property to his son-in-law for 2 crore 3 lakhs. And
now what can be done? How to solve this problem then? All right, whatever.
The other property was already sold, which was never contended before a lordship.
It was sold on which date?
19th February.
18th February.
No. The auction was 18th February. And 19th February, we received 25% from the auction purchaser. The amount
18 to 2026.
Yes, ma'am.
Yes.
Our order is 17 to 2026. Which our order related to which property?
Bhubaneswar property. That is Schedule A, Lordship may kindly see.
Where is that?
No. There is no mention.
That is where the OP3, the auction purchaser restrained from alienating
property. Therefore, it was already auctioned in his favor.
Yes.
No, this is piece of.
Let me clarify the yes, I think it's come.
Let
him.
The Bhubaneswar property. Lordship may kindly see the
two properties.
There are two properties.
Yes.
One is Bhubaneswar property, one is Cuttack property. The MOU which was referred there in the order sheet also, my lord. The MOU referred to, that is page 11 it starts of the writ petition. And the schedule of property is at page 18.
Which property?
That is Bhubaneswar property, Vipul Gardens, Bhubaneswar.
I'm not.
So that is where his contention was that instead of 2 crore 3 lakhs, the bank sold to the OP3 for 1 crore 84 lakhs 19,000 through the auction, which was not in consonance with the MOU entered between the parties. So that day I accepted. There was a mistake from the bank. So let the auction be set aside. We will refund that 1 crore 84 lakhs 98,000 to the OP3 and let him hand over the peaceful possession to me. I'll go for the fresh auction. Your lordship has recorded that we'll go for the fresh auction.
That is one part, my lord.
So the Cuttack property was never argued that day. Otherwise, lordship would have passed the interim order against the bank not to go for.
Not to hold the auction.
So the order was against the OP3 not to further create alienation.
Because he had already bought the property.
Yes, right. Yes.
So now the content.
One loan, my lord, to one term loan and overdue. Term loan was for 2 crores, my lord. And cash credit overdue was for 3 crores. 3 crores, man. Since my mother suffered cancer and still has a I considered I have set up a proposed purchaser and I asked the bank I will sell the Bhubaneswar property and the term loan will be completed, my lord. That is the tripartite agreement. But bank sold that Bhubaneswar property, violating the tripartite agreement, my lord.
Why bank did that?
Lord, there was a bona fide mistake in MOU. 1 year was given. The officer who signed, let me put forth, my lord, he was not aware that 1 year can be given to a borrower to sell that property, my lord. That is not even conscionable. But he agreed somehow. So I agreed to set aside that sale, entire sale. I did not contest. I agreed that there's a problem with the bank. That mistake happens. So MOU was for 1 year. That officer who signed, he was not aware of. Because 1 year not given to any borrower, my lord, in banking industry. But that is there. I can't improve on that. So we agreed that, okay, that was a problem. So let the property be handed over to us. We'll return that money to OP3.
Who OP3?
OP3, the son-in-law of the petitioner.
Your own son-in-law?
Yes.
No one is applying.
Huh? No one is applying.
He has not applied.
Relation or not?
Yes, I will ask him to. And second, next part.
First part, let it happen.
Yes, ma'am.
Then
yes,
we'll go to the next part.
Yes, ma'am.
Now he has explained.
Yes.
Some mistake happened.
Some mistake. Then next part,
we'll set aside that auction now.
Yes, ma'am.
Okay.
Yes.
You is son-in-law only.
Son-in-law. Yes.
Son-in-law only.
Yes. So next part, the cash credit account, my lord. The overdue was only 20 lakhs rupees.
Now first let this be done first.
Yes, ma'am.
Now you agree.
We'll return that amount by 10th April in a DD.
Yes.
Drawing in favor of the OP3.
Just write down and do it.
My lord. And on the same day, he should hand over peaceful possession. Because he's enjoying possession as or not.
No, we'll direct him to it.
Yes. I will.
Yes. So, and then bank will go for the fresh auction of the property in accordance with the law.
Just write down memo. In terms of that, we'll make the order. Give the paper. Learned panel counsel appearing for the OP bank, having taken the court through the case papers and also the tripartite agreement, very fairly submits that the auction of the security property of Bhubaneswar, he set it not, and that he is going to remit the auction amount of rupees 1
crore 84 lakhs 98,000. That is mentioned.
84 lakh 98,000 to the auction buyer, who is none other OP3, who is none other than the son-in-law of petitioner here. On or before 10th of April. Why 10th, brother?
31st March is the banking problem.
2026. First time. The said OP3 has chosen to be absent despite service of notice. Service have happened? Service of notice. And therefore, we assume that he has trust in the court and what the court would do. Personally, in the above circumstances, the memo filed by the bank's panel counsel this day reads as under. You have to write something like that. Reads as under. Next paragraph. In the above circumstances, the auction held on
30th December 2025.
Of the Bhubaneswar property is set at naught. Any sale certificate you have given?
Sale certificate also issued to him.
The
OP3.
The OP number 3 shall surrender back the sale certificate dated. Sale certificate issued pursuant to the auction. Immediately
16/1/2026.
Certificate dated 16/1/2026. Immediately on the receipt of the money remitted by him as indicated above. Then what will you do?
And also the physical possession of the
He is
property.
further directed to deliver back peaceable physical possession of the subject property to the bank for being notified for auction, to fresh auction.
The date of handing over also should be on same day. 10th, I'll give the DD and so that he gets 15 days time to
It hardly
prepare
needs
for.
to be stated that the handing over of a bank draft,
Demand draft.
bank demand draft for the above amount by the bank to OP number 3 and delivering back the subject property by OP number 3 to the bank shall happen simultaneously, contemporaneously, and without any disturbance. First off, which police station it is? We'll put the police inspector there. So that he should not create any ruckus.
Well, the full garden thing, I don't tell him inform.
The jurisdictional inspector of police is directed to be personally present at the time of this transaction to ensure peace and tranquility and smooth accomplishment. First one. The above order is made consensually between the petitioner and the bank. Come on. OP number 3 remaining ex parte remaining being kept ex parte due to unexplained absence. Stroke representation. Okay. A carbon copy of this order to be shared with the we'll call this matter after
one request, my lord. Bank may auction it at a lower price. I will set a prospective purchaser who can actual price.
11th, we are calling this matter.
Yes.
Well, in one day that will not happen. 10, 11.
Then after 30 days time will be
No,
then after 30 days time will be there for
call this
sale.
matter on 15th.
So far, Kotak property is concerned, my lord. They have made it auction, my lord, on 18/2 after this course order, my lord.
But that court order did not relate to it because it is 18/2.
No, my lord, you also see the rate person relates to it, my lord.
Maybe, but by the time we made that order, that this was not, it did not extend to that property at all.
No, my lord, but rate petition extend to that, relation to that, my lord.
We'll look into next thing.
Yes, my lord, you also can at least say no person action, no consequence action shall be taken, my lord. No consequent action shall be taken since they have already purchased. And in the meantime, I have purchased. That's only overdue amount, my lord.
The
Overdue amount
purchase has already deposited 25%.
No.
Who will come then?
Don't issue the sale certificate. Till next date.
31st March is paying, my lord. Then nobody will come to the bank, my lord, to purchase.
I have deposited.
This is happening, my lord.
And
also, he should approach the DRT, my lord. On section 19, my lord, one section 19
This is the house they can
19 of SARFAESI Act speaks about that if he can prove that the entire SARFAESI proceeding was null and void and not followed by the bank, DRT has ample power to restore back the possession and grant compensation. What else you need, my lord? If you can prove section 19, also make a listen.
My residential property, my Article 21 by
What 21? But that you can put 41 before the DRT.
I have what they're doing, my lord. I'm one. But in the meantime, I have deposited, my lord. Overdue amount was not 20 lakhs. I have deposited 40 lakhs. They are not taking into account, my lord. I have already deposited 40 lakhs, my lord.
But
They have not taken it account, my lord.
So you should have brought it when 13-2 notice was there and other aspects.
Yes, my lord. 13 notice there. After that, I have deposited, my lord.
Right of borrower to receive compensation and cost in certain cases, if the debt recovery tribunal or the court of district judge on the application made under section 17 or 17A of the appellate tribunal or the high court on an appeal preferred under section 18 or 18A holds that the possession of the secured asset by the secured creditor is not in accordance with the provisions of this act and rules made thereunder, and directs the secured creditors to return such secured asset to the concerned borrowers or any other agreed person who has filed the application under section 17 or 17A or appeal under 18 or 18A, as the case may be, the borrower or such other persons shall be entitled to the payment of such compensation and cost as may be determined by such tribunal or court or district judge or appellate tribunal or high court referred in 19B. Because in the case of JK, that is mentioned because before that, before the constitutional amendment to the JK state was, the 370 was revoked. So the district judge is coming in here. Otherwise, if the DRT or DRAT, they finds that bank did not follow the SARFAESI proceeding, they can restore it back the possession and grant compensation.
My residential house.
what is not, see, Dixit Krishna Shripad application holds that the possession of secured assets by the security is not in accordance with law.
If the DRT finds it, that the process, because the cause of action for the borrower starts from the 13-4 when the possession is taken. 13-2, no cause of action because he has a right to give a 13-3A reply to. So 13-4 is the possession. Whether it's a physical possession or a notional possession, that also decided below the Hon'Ble Appellate Court. It said only the possession. So when the possession was declared by the DRT is null and void or a defective, or the bank did not follow the process as per SARFAESI, it can be restored back to the borrower or any other person agreed who has filed the section 17 with a compensation. If tomorrow the DRT finds that the possession was not taken in accordance with SARFAESI, they will restore it back.
Who is the person who has bought that property?
Normally he becomes a party to the proceeding, the auction purchaser.
Here he is not a party.
Yes.
Here he is a party. No, because
he is not a party.
Second property is not a party. Second property, first property is a party, his son-in-law. So if he approaches DRT, the auction purchaser will give the details.
This is my residential house, madam.
The issuance of sale certificate shall be subject to outcome of this petition. Next one. For the 15th shall come this matter. 16.
Bhafnamoto says it should not be entertained.
No, what is that? We are only saying, you are, if you issue, because you say that once you remit the money, you can't hold back from the sale certificate.
I have deposited 40 lakhs rupees. They are not taking account of it.
But the property already sold. Thereafter also
already sold. Only thereafter you are making all this exercise.
Yes.
My lord, this is cash credit amount, my lord. Overdue amount only 20 lakhs rupees. 3 crores overdue amount only 20 lakhs rupees. I have paid 40 lakhs rupees.
One account is NPA, all accounts NPA. That's the law. So it cannot be.
I have regulated the account, my lord.
Yes.
Item 29, writ appeal 540 of 2025.
Lordship, it's a covered matter. If your Lordship permits me.
No, Lordship, may kindly see page 176 of the brief, where the Honorable Single Judge altered the decision of the writ petition in the IA subsequent to the disposal of the writ petition on the premises that he had quoted a wrong way, that he had filed that way, but again he came before in way IA and said that no, I had not filed, it is some other person filed, so my matter is not covered by that. On that premises, the writ petition was earlier allowed. In IA, correcting the error, it was dismissed. Now he is citing another decision before Lordship saying that it is covered. I have examined that. It is in fact covered by that decision, but that decision was not cited before the Honorable Single Judge.
Now it is covered.
Now it is covered.
Continuation of the original proceeding.
Agreed.
So whatever is there.
I am only placing the facts. Only that your Lordship may see.
All that exercise.
All that exercise to examine, and if it is covered, then in the light of that, it can be disposed of.
Now it is covered by the judgment.
Now he's saying that we will consider that. We will consider.
His mistake, all these things happen.
Your lordship, already they have.
Already you have done a lot of mistakes. Again, don't mess out.
We'll consider in the light of the judgment with citing.
Did not tell that.
Already they have notified and give relief in that judgment.
Maybe, my lord,
They
we'll
extended
consider
already
it.
relief in that
If
judgment.
it falls within that judgment, my lord, we'll grant the similar benefit. I'm extending that submission. Lordship may modify the order.
This is issued to whom?
Issued to the person concerned in the
Person concerned in that particular case.
that particular case.
Torrents and
So similar benefit
Yes.
is to be extended.
I am similarly situated person.
Any serial number? 29.
29, my lord.
Appellant's WPC number 8620 of 2020 was allowed by the learned single judge while the order dated 28/11/2024.
Yes, no, yes.
In the light of tribunal's decision in OA number 2595 of 2014, disposed of on 5/2/2016. First time. Subsequently, it was noticed that the appellant was not covered under the decision of the tribunal. And as a consequence, in terms of IA number 1699 of 2024, the learned single judge recalled the said order
16991.
16991 of 2024, recalled the said order and dismissed the writ petition. Wide order dated 20 January 2025, which is now put in challenge in the appeal at our hands. First time. We notice that the subject matter of this appeal is substantially similar to the one in WPC number 8627 of 2020 between Sri Taranisen Patnaik versus state and others, state of Odisha and others, disposed of by the learned single judge in a wide order dated 25/6/2024. Single judge or DB?
Single judge.
24. Wherein relief has been accorded to the litigant therein. First one. Counsel for the appellant has placed on record notification, government notification dated 9 January 2026, whereby the order of the learned single judge has been implemented. First one. Last sentence is something. The said notification reads as under. Next paragraph. In view of the above position emerging from the records, much adjudication and deeper examination of the matter need not be undertaken by us. There being no challenge to the order of the learned single judge in Pattanayak's case supra.
That I am not very clear.
No, we are saying the material is no proceed for dismissal. Examine all that. The examine result that is put in challenge. That WP, that's also important. Suppose if that is put in challenge,
Yes.
and it is stayed, then he may say we cannot allow this appeal.
Then again error.
Again one more case. Verify whether appeal is filed against that order.
No, appeal may need because of compliance.
Sometimes because of threat of contempt and other things.
Yes. But had it been so, here they would have mentioned subject to resolution.
Yes. This WP, whether appeal is taken.
But he is still there or he has retired?
Yes, your lordship, she is still in service, only three months service left. 30th June 2026 is retiring.
Here the man has retired.
What says?
But in that particular case,
Well, if this was put by challenge, they would not have implemented that order. But just let us announce. Yes, in the meaning text. In the above circumstances, the appeal is allowed.
No. Appellant's case may be considered by the respondents.
That's what
If false.
that order has to be set aside now.
Yes. Not a
That
question.
this appeal is allowed. Semicolon. The impugned order of the learned single judge is set at naught. Semicolon. The writ of mandamus issues to the respondent state.
Yes. Jurisdictional authorities.
To consider case of the appellant in the light of
Yes.
the decision of learned single judge in Taranisen Pattanayak's case supra within an outer limit of 8 weeks.
8 weeks.
8 weeks.
All contentions were kept open.
First, in that connection,
Yes.
all contentions of the parties are kept open.
Grateful.
may I pray your lordship? Sir, preliminary statement, preliminary paragraph may.
No appeal is filed.
Your lordship, then I apprehend that may be mistake in the preliminary paragraph.
Wait.
What dictated, just check it out. Otherwise, I have to file correct.
What happened?
See, actually,
Whatever order the tribunal, the learned single judge passed. That order is put in challenge before us. The power of the appellate court is coextensive with that of the learned single judge.
No, sir. Actually, what happened? Tribunal's order. In tribunal's order, that was I was not a party. I was a meritorious candidate, having 5 outstanding CCR. I am a similarly situated person, like that person who has filed the case in the tribunal. On that basis, government gave promotion. Government did not file any appeal in higher forum. So that that decision became a finality. So when after that gradation list was finalized, in gradation list, my list serial number is 339. More than 20 number of juniors were promoted. As a result of which, I filed this case in 8620 of 2020. Case number is 8620 of 2020. In 8620, WPC 8620 of 2020, Law and Single Judge gave this order. He allowed my prayer, writ petition was disposed of, and certain inadvertent mistakes regarding the factual mistake, because I have not filed that case. I told that I am a similarly situated, as a result of which I was considered by the government and I was given promotion. So when I identified the mistake and brought to the notice of the Law and Single Judge, then at that point of time in the IA it was dismissed, writ petition was dismissed, order was reversed.
That is what we have written.
Exactly what your lordship have reflected.
So we have written the same thing, brother.
Same thing.
Just read that first paragraph.
First paragraph, just first paragraph.
Read loudly.
Subsequently, it was noticed that the member of the tribunal and as a consequence, moving down to 1699 of 2024, the third order and dismissed the writ petition made order feature 20 January 2025, which is now 14 January.
That order is put in challenge before us. Appears to be correct.
Yes. Much obliged.
Yes.
Item number 30.
Yes, sir.
Sir, item 30 means counter affidavits from
Body is also here.
Yes, my learned senior is also. Counter affidavits are all there. Everyone has filed. Your lordships had given me permission to file rejoinder. Unfortunately, there was an untoward incident with the managing director of my client, and for which he could not come. He's an old man. He could not come for signing. Lordship may give me enlargement of time. Another 10 days, I'll file my rejoinder.
Only thing I submit to your lordships. This is a matter. I am surprised why the petitioner is pursuing this case. But I'll just tell your lordships what. We are the person they apply. Just 2 minutes only. We are the persons whom they apply. There's a requirement of land. That is the way the body of the state, if we call, they apply for a requirement of land. So we recommended his case for a requirement of land of 56 acres positively in his favor. He went to the authorities and said that I want to apply for this land. That is ITCO authorities. That's another authority. And we want this land. What the ITCO said, this land has been already recommended
for another person
prior to you, and hence you can apply another land. That is at 24. If he's serious in the industry, he should be applying for another land. How can he is a prior applicant and he has already been allotted. This is the impugn order before lordships. And this is being pursued.
I will demonstrate.
No, there's a demonstration is always possible.
My case.
But I appear for the prior applicant.
Things are not complete.
This is a prior applicant applied.
This is Millard's.
Lord, I pay for the prior applicant response number 8.
Prior applicant, Lord.
is also
a case of prior applicant. Theirs is not. I was prior. That is what my endeavor is to demonstrate.
I am not in this type of cases.
I am not
a serious industry.
I am not today.
No, you'll also be fixed at date. And a last chance. Because this litigation creates problems for the organization because they can't also hand over.
We are also not able to proceed, my lord.
Not proceed because the matter is pending.
That's right, my lord, it impacts us.
Can we call it on 15th of April?
My lord, can it be 10th, my lord, 10th of April if it's not in
I'm sorry, Mr. Dhruv, and I'll 10th, I'm also not there. I'm a matter.
Mr. Party will not be.
15th there would be.
Let me be more candid with your lordship. The person had an accident. So
No, the accident, everything is understandable. We have all sympathy for the person.
No, it's not about sympathy. It's just about some further time to help.
15th.
No, I have some difficulty on the 15th. Can it be 17th, my lord?
After 15th, any day.
Or 22nd.
17th, my lord. 17th or 24th. 24th.
Friday.
Friday.
Normally we don't keep it.
Friday, single.
22nd.
We each brothers, we depart from each other.
22nd would it come into your lordship's 22nd?
23rd, my lord.
23rd.
Yes.
It's all right.
23rd.
Do you have any comment?
So I'll remind your lordships about the case.
23rd.
Lordship. Lord, can it be high up on the board, my lord, if it's not in
Already in the higher board, all matters are reached.
Yes,
all matters reach in this code.
In the list, we put very few matters.
All matters in this code reaches. Grateful.
Ungrateful. Sorry. How many matters are posted on 23rd? Mr. Padi, 1 second, sir. Sir, no matter. No matter. No matters are posted on that. All
Very well. Very well.
Give them. Call that matter. Is he present?
I thought your lordship your lordship can pass that order about that rejoinder if any within this time.
Heard.
Made by the petitioner.
Counsel for the petitioner and learned senior advocate Mr. Padi and also
Roommate.
Fine. So, first of Mr. The counsel for the petitioner seeks a short accommodation for filing of rejoinder to the counter filed by the other side. First. It is agreed between all the parties that the matter will be heard on 23/4/2026. First time. Call on 26. Not. The first one method. 11. Yes, skip it. Let's try it. What notices to the other advocate, not advocate.
Real party was no respondent.
Serial number?
15 of the weeklies.
Weekly.
Meantime, the respondents died,
In 14. Who appears in 14? Second list. Weekly list. It appears party is dead.
Substitution as
in serial number. Yes. Fine. So, we are told at the bar that respondent, sole respondent is okay. And first one, steps to be taken in respect of the DC. Call up 4 weeks.
Not on next week.
How next week? 90 days they will have period, na? Under the CPC to file application, they have 90 days.
Died since 27/12/25.
After collecting all the documents, they have.
It is come to their notice.
Died on
27/12/19.
First one, steps to be taken with respect of the DCs. Call after what is IA? A for?
IA for substitution. IA.
You have brought the application.
My letters.
They
have to file.
LR, is it LR application?
LR.
This I is by whom?
By the
LRs of
LRs of
legal heir of the receiver.
that is what.
Is it? Anybody can file LR appeal, not necessarily the dominant parties. You have sought for setting aside abatement. Huh? 25
They have filed for substitution.
implement they have sought for.
Yeah.
That's all it. Anyway, your job is saved now. Otherwise, your appeal will go. Tell that order. The sole respondent, Mr. Sunil Kumar Das, having died on 25, 27/12/2025. Come on. Ideally speaking, the application ought to have been filed for bringing LRs of the deceased on record in his stead. First off. However, no such application has been filed by the appellant state. First off. Next paragraph. Now, LR of the deceased, the sole respondent himself. How many?
One.
Brought sole respondent, namely?
Namely, this is Srimati Manjusha Das.
The widow. Widow Srimati Manjusha Das has moved this application seeking her arraignment. First off, such applications can be treated as LR application. As observed by the Madras High Court. First off, there is no objection from the learned AGA who represents the appellant. First off, had there been objection, we would have disposed of the appeal as having statutorily abated. First off, next paragraph. One more sentence. Justice of the case warrants that the application be favored and the applicant widow be permitted to represent the estate of the deceased. First off. Ordered accordingly and application is disposed of. Necessary amendment to be effected by the appellant.
Only cost title is to be filed.
Necessary amendment to the cost
title
to be effected by the appellants forthwith. Yes. Call after 2 weeks. Yes, sir.
In this 231, that matter also had its earlier panel. When CRPF constable pilot in recruitment, he was found not medically fit. Then this honorable court sent for medical test pilot to AIMS Bhubaneswar. AIMS Bhubaneswar found me fit. But the judgment is subject to medical fitness pilot. That was challenged by also on hard. It is 231. Can it be it's not 7th of April in the supplementary list? There short matter.
7th, how many minutes?
6th or 7th, 8th?
10 minutes. 10 minutes, not possible. On
8th?
On 15th, no, the whole that we have already put. 8, 9, 10, how many? 8 and 9.
8 said 10 minutes.
10 minutes. 9.
8 said 3 minutes.
8
minutes. 8. And put on 8.
8.
In daily list. daily list.
I told 231.
231.
231 of the weekly.
231 of weekly.
Item number 18.
Item number
18.
18
18.
in the list.
18 in the list.
That weekly list.
No, madam. This is in the weekly list, madam. Might be taken up on 7th, madam. Because
weekly list will
next week I will not be there. That is why.
Therefore, I also may not be there. But we are repeating the list, na?